lordships, my lord. Still in different bench, my lord, but that will again sent to your lordships, my lord, on criminal matter,
What matter?
criminal quashing matter. May I pray for 30th, my lord, 30th of January,
30th.
or any date convenient, any hearing date, my lord, because it is already part of
Yeah, any date. You give us your date. 30.
30.
All right. It's not 30.
May I please your lordship? I'm also praying for listing of a matter, lordship. This is regarding family pension. On 25th, lordship.
25th. What is the when was it filed?
Last it was listed on 2/8/2023, lordship, August.
25th. All right.
Deeply obliged.
Lordship, I beg to mention on writ petition, Lordship, related to pension matter, Lordship. It was
Huh?
last posted on
Ah,
9/10/2023. Can we, Lordship, 30?
not 30. February. Goes to February.
Then
For what? For admission?
Yes.
For admission.
Lordship, it
Let it
may
be-
be motion, Lordship.
Huh?
Motion. Data
Motion.
on motion. No,
Fresh matter.
no, Lordship.
Motion matter.
Yes.
Then let it be on 29th
Yes.
January.
Please, Lordship, I beg to mention item 43 of today's list, my lord. Lordship, here we are still awaiting instruction. Lordship, we have informed the petitioner 2 weeks' time may be granted, Lordship.
Item 43 at the request of Mr. Petitioner. Here for the petitioner, any objection?
No.
A joint request matter at the request of Mr. A. Chaliha, learned Standing Council Finance. Matter stands adjourned for 3 weeks. Prayer is not objected to by the learned counsel for the petitioner. Yes.
May I please, Lordship? Prayer for listing, Lordship, in 2019 matter, Lordship. Last posted, Lordship, 27/3/23, Lordship. Pension matter, Lordship. Little matter 30 January, Lordship.
12th February. 12th February. Yes.
Your lordship, with regard to item number 29, your lordship, may I pray the matter may kindly be adjourned, lordship.
Lordship, in this matter, I am for the petitioner, Lordship. Lordship, matter is pertaining to the termination, Lordship, regarding probation period, Lordship. And probation period, lien is yet going to be end, Lordship, in the month of February, Lordship. Lordship, I fixed on 13th of February, Lordship.
Lord, 13th or 15th, your lord.
Huh?
Either 13th or 15th, lord.
13th of February, Lordship.
All right, 30th.
Deeply obliged, Lordship.
May I please, your Lordship?
I
beg to
mention joint request, huh? Yes.
I beg to mention item number 26, your Lordship.
Hmm.
I have instructions to withdraw this case, your Lordship.
Item 26. Mr. H. Buraghwai, learned counsel for the petitioner, on instruction submits that the writ petitioner does not wish to press the writ petition any further. Accordingly, the same stands dismissed on withdrawal. Interim order, if any, stands vacated. You are for the respondent.
Respondent, Account General, on behalf of SK Medi, Respondent number 2.
MS so appears on behalf of the Accountant General. SK Medi, learned counsel for Accountant General. Yes.
May praise the Lordship. Lordship, with the consent of the other side, I beg to mention item number 39, Lordship. Lordship, earlier in this matter, our senior counsel was leading us.
So these hearing matters, we'll keep it in the hearing list. You don't have to mention.
Lordship. Obliged, Lordship.
Yes.
Learned Standing Council, and Finance Department takes time to submit the order for reinstatement as well as the logical conclusion of the inquiry report, my lord. Today, my lord, last 2 occasions, they taking time.
Yes, what happened?
I have taken the instructions, my lord, today morning. The file, my lord, the process is almost complete, my lord. It is now pending before the Commissioner and Secretary Finance Department.
No, process for what?
My lord, process, my lord, the inquiry report has been submitted, my lord. And my lord, the penalty has been inflicted. Now, my lord, the department is contemplating, my lord, to revisit the penalty. Because, my lord, the petitioner is going to retire on 31st of this month, my lord. So there is every possibility, my lord, that he may be exonerated, my lord. But nonetheless, my lord, the final decision is yet to come, my lord. It will be available, made available within, my lord, day or two, my lord. So under that circumstances, my lord, I am praying, my lord, to fix the matter on coming 29, my lord, Monday. Otherwise, my lord, if the writ petitioner insists, my lord, lordship can decide this application, my lord. It is only with relate to, my lord, whether, my lord, the petitioner has been, my lord, suspended, my lord, whether that suspension is reviewed or not. So the suspension, my lord, is not reviewed till date, my lord, because the final decision is
When are you retiring?
31st.
31st. As a
31st.
last opportunity, my lord, I am praying, my lord, for listing this matter on 29. If on 29, my lord, nothing is forthcoming, lord, she will take a call, my lord, decide.
No, 29th is too near. He's retiring on 31st.
31st,
Assuming you take a decision also,
my lord.
your orders will not be available on 29. When are they supposed to take a decision?
My lord, within a day or two, that is what I have been instructed.
As per instruction, my lord, tomorrow they are tomorrow.
All right,
Tomorrow
let
they are
it be
going.
all right, then 29th.
29 before that, my lord, I think,
Huh?
because of that.
Before that, there is only one day, that is 25th.
25th maybe.
So tomorrow, if they take a decision, it may not be available on 25th.
At least my son's on 25th, my lord. Because of that, there were only at least.
No, we'll have it on 29th. You are retiring on 31st. You are retiring on 31st.
My lord.
We'll have it on 29th. We want your instructions on 29th.
My lord.
Tell us what is to be done.
Yes,
Heard Mr. N. Bora, learned counsel for the petitioner, also Mr. R. Borpuzari, learned standing counsel,
finance, my lord.
finance. Mr. Goswami also
Yes, Lordship. Respondent for the Deputy Commissioner, Lordship.
appearing for respondent for deputy commissioner. It is submitted by Mr. Borpuzari that the suspension, this departmental proceedings against the petitioner has been completed, an inquiry report submitted, and there is a possibility that the department may revisit the we'll say the department, the disciplinary authority has not yet taken a decision
My
on the
lord.
matter and is
Yeah.
likely to be taken in a day or two.
My lord.
He submits that the matter be listed again on 29th in order to enable him to apprise the court of the decisions taken by the departmental authority, by the disciplinary authority. Mr. Bora submits that the petitioner will retire on 31st of January. As such, on 29th, if no instructions are forthcoming, matter be taken up for a disposal.
Right.
Accordingly, let the matter be listed on 29th
I'm so
by
obliged.
29th of January, by which date the respondents will apprise the court of the decisions taken. And if such a decision is not placed before the court, and if instructions are not placed before the court will proceed to hear and dispose of the matter on the basis of the pleadings available on record.
My lord.
Ma-
My lord. I'm so obliged, my lord.
Here and my affidavit of SSA, my lord, is ready, my lord. We'll file it within a day or two, my lord. Because of the continuous holiday, it will be filed, my lord. Today is also a holiday, my lord.
Today is a holiday.
Today is a holiday, my lord.
Why?
Because of Netaji Subhash Chandra Bose.
It is
But we'll
submitted
fix on
by
1st of February, my lord. In the meantime, we'll find my lord.
Mr. S. Bora, learned standing counsel, SSA, that the affidavit is likely to be filed within a day or two, within this week. And therefore, prays for further time to enable the department to file their affidavit. Mr. AMS Mazumdar, learned counsel for the petitioner, does not object to the prayer. Accordingly, let the matter be listed on 2nd of February.
Problem, lord.
Do we take it up in the second half? Because it's, how long are you going to take?
My lord, I will be taking minimum 1 hour.
So let us have it in the second half. Let us go through the other matters on the
Yes,
board.
yes.
Well, Lordship, what Lordship can do, the other matters the Lordship can take up. And in the meantime, if somehow we get a chance, we will be,
Yes.
we'll take a chance.
If,
Before one
if
of
the matters are not
Yes.
completed, then all
We can
completed, then before 2 also we can take it up.
Yes.
I'll be showing the rules and the
This matter, I have paid time, my lord, for that budget matter.
For?
Budget sanction, my lord, the remaining area salary, my lord.
Ah,
So it's yet to be sanctioned, my lord. We pray for some time, my lord.
yet to be submitted.
Yet to be sanctioned, but
Sanction.
it has to become, my lord,
Sanctioned by whom?
by the government.
Well, finance will obtain the instructions. Who's there for the finance? You have submitted before the finance department.
Yes, it. Maybe after a month or so,
Let the, who's for the petitioner?
they're absent, my lord.
Well, then, in the absence of the petitioner, Mr. J. Roy, Learned Counsel for the ASTC submits that the budget for payment of area salary is already sent to the concerned department in the government, but the same is yet to be sanctioned. Accordingly, he prays for further time. Since none represents the writ petitioner, let the matter be listed again after 1 week.
1 month.
1 week. There is nobody on the petitioner's side. Let us find out. None appears when the matter is pulled up. List next week. Yes.
May it please your lordship. My lord, in this case, petitioner was appointed in the year 2002, October 2002, my lord, as rifleman. And thereafter, he was sent for basic training. And during training, my lord, he got injury. And in October 2003, my lord, he was discharged from service, saying him he is invalidated, my lord. And kindly see discharge order, my lord. Page 17, my annexure 1 of my writ petition.
Page?
Page 17, annexure 1 of my writ petition.
Hmm.
Ground for discharge on medical ground, my lord.
Page 17.
Yes, my lord.
Yes.
Thereafter, my lord, kindly see annexure 2, page 18. Petitioner was directed to report, my lord, in the respondent authority office for his invalidation, my lord. As he was invalidated out from service, my lord, because of injury. Then, my lord, next page 19, annexure 3.
Yes.
My lord, for granting disability pension, petitioner was asked to, my lord, to submit pension document. All these are, my lord, their letter for giving him disability pension.
Then?
Then, my lord, Again, I was asked to submit all the, my lord, bank details, undertaking. Everything I have submitted, my lord, but till today, my lord, they have not given anything, my lord. Then, my lord, I filed this case, my lord. Now they are in the affidavit in opposition. They are saying, my lord, I am not entitled.
Why are you not entitled?
They said that I have not completed 10 years of qualifying service. My lord, what my lord rule is that, my lord, for granting disability pension, 10 years is not mandatory, my lord.
What rules?
My lord, I can show the rule, my lord, and
What are the rules? Which rules?
my lord.
What is the name of the rule?
My lord, CCS extraordinary pension rule, as well as my lord, CCS pension rule 38 also says, if I am disabled because of any injury, my lord, I am entitled. My lord, may I give the book? My lord, one thing, my lord, one similar judgments are passed by this honorable court, my lord,
Hmm.
as well as by division bench also. My lord, I want to show, my lord.
First tell us the rules. Explain to us.
Yes, my lord. This is the book, my lord. Extraordinary pension rule says, my lord. May I read, my lord?
What are you reading?
CCS extraordinary pension rule,
CC as extraordinary. Is it enclosed to the petition?
my lord.
Have you enclosed it to the petition?
I have not enclosed, but they have enclosed, my lord.
They have enclosed.
Yes.
Very nice. What
Because
is the
my-
page number? The relevant portion.
My lord.
Yes. Annexure C.
Yes, my lord.
Yes. Tell us.
My lord, before that, I want to show page 95 of their Annexure A, page 95 of their affidavit in opposition.
Annexure A.
Page 95 of the affidavit in opposition. This is, my lord, 19 May 2020.
Yes.
Yes, I have not received anything. I have, my lord, submitted legal notice. Reply to that, they have said, my lord, relevant para, my lord, 3.
Yes.
Your client so and so did had sustained injury, my lord, so and so during battle physical efficiency test while attending the basic training at the so and so. As he was unable to complete the basic training, unlikely to become an efficient soldier due to his injury, was brought before the Invalidation Medical Board as recommended by the specialist military hospital and accordingly invalidated out from service with 40% disability on so and so. It is intimated that your client so and so is eligible for grant of disability pension in accordance with the percentage of disability suffered by him as certified by the medical authority as per CCS Extraordinary Pension Rule 1939. All personnel of Assam Rifle, those who are discharged from service due to disability, are being shortlisted and the same cases are being taken up to the competent authority for further consideration.
Hmm.
But rule, my lord, page 74, Annexure E. And I have the book also, my lord.
It's all right. You point out from the relevant portion.
Relevant for. Lord, they have not, only they have annexed that 10 years service is necessary. And therefore I am giving the book, my. Dada. My lord, invalid pension rule 38 of CCS pension rule also says that, my lord. Invalid pension may be granted if a government servant retires from service on account of any bodily or mental infirmity who is permanently incapacitated him for service. This is rule 38 of CCS pension rule. Both the rules says, my lord, I am entitled. And my lord, similarly situated persons are getting also. And this honorable court has passed many orders. I have some similar order also. May I?
Where is
my
that
lord-
book?
Dada, log na. LED.
You're referring to extraordinary pension.
Both my lord says, my lord, extraordinary based on 3A, my lord, left side,
230.
and invalid pension also, rule 38.
3A.
Yes, my lord. In the similar order, it is clearly written the rule.
What would you? Hmm. Yes. Which judgment do you want to refer?
Both, my lord, one division bench judgment, my lord is also there, my lord. One single bench. Similar, my lord. Division bench, my lord, department approached this honorable court challenging the single bench order. And
This single bench judgment was not appealed against.
My lord,
This single bench judgment
yes,
did not go for appeal.
go for appeal by the department, my lord. So department has,
No, these are two different matters, I think.
yes, my lord. Single bench judgment at present do not have in division bench, but it is written in the judgment.
Where is that report of your medical board?
My lord, page 58 of their affidavit.
58.
Last portion is important, my lord. This individual is a case of suprachiasmatic fracture, has injured on 16 March 2003 during BPL. He was referred to so and so. He has recommended to be invalidated out of service in medical category A5. Last portion. And in their affidavit also, they have clearly stated. Page 59, right hand side, my lord, percentage 40%.
So the only ground is that he did not complete 10 years.
My lord, but this will come for normal pension, not for disability pension.
Yes. What do you say, madam?
Lordship, apart from 10 years lordship, another condition is that it has to be attributable to or aggravated by service condition, which as per the board, in case of the petitioner, is not attributable to or aggravated by service condition. Lordship had
Oh,
gone
what
to
is the meaning of service
Yes,
condition?
Lordship. Lordship may kindly come to page 72, Annexus C.
Yes.
So here 3A1A, disablement shall be
1A.
disablement shall be accepted as due to government service, provided that it is certified that it is due to wound, injury, or disease which is attributable to government service or existed before or arose during government service and has been and remain aggravated thereby.
Now, what
So-
is the meaning of government service?
Here, Lordship, he is undergoing training, Lordship, and there he had injured himself.
Where is the definition of government service?
Government service.
Any definition? If you look into the rule 2, do you have civil services extraordinary pension rules?
Yeah.
You have?
I
Yeah, look into rule 2.
Existed before or arose during government service.
Do you have a copy?
I don't,
I do copy to you. Respondent. Just see the underline portion.
but Lordship. Whether the appointment is permanent or temporary. Your Lordship, that is the finding of the medical board, Lordship, and if he is not satisfied, and we have also intimated him, he should have gone for review medical board within 1 month from the date of passing of the.
No, he's not aggrieved. His claim is that if you find me medically unfit during this BPET, you want me to be out of the service, then I'm entitled to disability pension, that's all.
That is Lordship. So in that case, if he is, his condition is that he is not attributable to, that is the finding, and as per this rule 3(1)(a), he should be is attributable to government servant or that is the board find him as
No,
not
no,
attributable to.
this is not during selection. This is after selection, during the training,
During the
prior to his confirmation.
Lordship.
So that makes him a temporary employee, if not a permanent employee. But he is in employment. He is earning some remuneration, salary, wages, whatever you have to pay him. This is not a case where he came for selection and then suffered an injury and now he is claiming a pension. This is not a case like that. He was selected. He had to undergo medical test. He had undergone medical test. He was selected, shortlisted, sent for training. During in training, he suffered this injury. Now, this training will determine whether he is to be enlisted for permanent service or not. That he did not. So therefore, under these circumstances, whether in view of the explanation or in view of rule 2, whether you can say that he is not in government service.
That is not there, Lordship, but he had put only 1 year, 19 days of service. That is there. It is not a case that under CCS he is not he is not entitled to, because he has less than 10 years. These are the main 3 grounds that is taken, that no review medical board.
What do you say about, no, review medical board is to be by whom? By him, by the person concerned.
By the person, if he is not, that his service condition is not attributable, that is the finding of the medical board.
Where is it? Page number?
That provision is, Lordship, Annexure E.
No, finding of the.
Finding is, yes, Lordship. That page 58.
8.
page, no.
You tell us that even under disability, there is a particular period of service he has to undergo. And assuming he has to be paid, what is the amount he'll get? It has to be calculated on the basis of the service rendered pension.
Under CCS, he has to be at least 10 years of minimum service for pension,
That's for regular.
regular pension.
Ah.
And second is this rule 3.1 is that
310.
3.1 Lordship Annexer 3A1, that is extraordinary rule, that is for if it is service is attributable to government service, but here he was recognized as non-attributable to. And if he is not attributable to, so he, as I have stated in my affidavit,
Where is this page number 58? There is at the end of the last line in page 58.
yes,
He was recommended to be invalidated
Lordship.
by medical category A5. Last page,
Yes, yes.
last line 58.
That is the orthopedic surgeons.
Yes. So where is that opinion? Is it a part of the pleadings here?
Lordship. Lordship, page 58, clause 2, opinion of the medical board. Above, Lordship, above this.
No, we have seen that. What we want to know is there is a specialist who has recommended.
Yes,
That recommendation has to be on the basis of some opinion.
Lordship, that, yes, Lordship, opinion of the medical board. Lordship, kindly come to page 58, above the page 2A. In respect of its disabled medical board on the evidence before it will express its view as to whether it is attributable to service.
No, I want to see the views. Where are the views?
Then
The
I
medical board.
call for the record, Lordship.
You call for the record.
Yes.
Let us find out. But also, your argument is that, you see, in the division bench and a single bench has held that this 10 years period is for regular pension.
Lordship.
So,
And many judgments, my lord. Today I do not have.
no, if you must have it. You should,
Yes, my lord.
because there is one thing that you have to keep in account is that he's put in service for only 1 year.
Yes, my lord. But
And if that be the principle, then tomorrow somebody gets selected, day after there is some injury and is entitled to pension. That also has to be taken into account.
And more so, Lordship, here he had approached after 16 years. So whether his
His approach after 16 years is probably he was not aware.
Annexer H, we have also sent his
no,
case
my
for
lord, I have
the
submitted.
higher authority, and Annexer L, higher authority has rejected mainly because on the ground Annexer L, page 103, that this report he had approached after 20 years from his invalidation. So as per under rule 8, servant, he had not filed any appeal against the decision of the medical board, and that is the ground where they had not forwarded his case, although some of the persons were given the benefit, Lordship.
My lord, I have shown the reply to the legal notice that is of 2020, my lord. I was in complete connection, my lord. Representation also I have submitted. They are asking me document again and again. I am submitting again and again.
20 is clear, Lordship, but invalidation is of 2003.
It is their duty, my lord, because as I have submitted all the documents as said by them, my lord, it is their duty to give me, my lord. They have not given. I was compelled to approach this.
What is his disability
40%.
and what is the requirement for grant of disability pension?
My lord, rule does not say anything about length of service or percentage.
Let us see that CC is extraordinary. What is his disability? 40%.
40%.
He's put in service for 1 year.
1 year, 19 days.
Your rules are clear. Rule 8 and 9. Read with the judgments of this court. Have you gone through the judgments?
Lordship, there are some this.
Both the judgments? You tell us if there's anything you want. We just wanted to see the
Opinion of this expert is page 61.
Hmm.
But after this opinion, the board has founded him not attributable to. The expert has
opinion
not.
is here.
Yes,
Okay.
Lordship, page 61. Opinion of Baruri, radio specialist orthopedics, page 61.
Hmm.
Is the type copy and page 60.
So he's recommended.
Yes, Lordship.
Hmm.
Recommended to be invalidated out of military service.
What is category 5?
Category 5 is there is this is his injury is permanent, Lordship. And that is also written in page 59. Page 59, clause 3. Percentage of disablement 40%, probable duration of this degree of disablement lifelong, composite assessment, all disabilities 40%. And then his next page is that whether the individual is need to further treatment, or if so, of what nature and for how long it is likely to be required. Yes, orthopedician at civil at home.
Okay. Anything more?
So these are the three main grounds that he had approached after such a long delay and no review medical. He had not called for any review medical, although there is a provision for review medical if one is not satisfied with the finding of the medical board. And
You're
Lord-
not getting the point. You see, he is not
Lordship.
unsatisfied.
Yes.
If he is given a pension, he doesn't have to work. He's put in only 1 year of service.
Lord-
So he's not unsatisfied. So he doesn't go for review.
No, that is because his case is not attributable. That is, he is not entitled for pension.
No, but
And
then in view of the division bench judgment, how
Lordship.
you can't make the submission? Unless you want to say that the facts involved in the division bench, before the division bench was different.
And but here the delay part is also
But
there.
delay, you can keep aside the delay for the time being, because this is, see, pension is something that if we hold that he is entitled to pension, then this is something he has earned. It is for the department to have granted him the pension. You can't find fault with him for coming up to the court after some years. But if you want to argue on this fact that the facts are dissimilar as before the division bench or the other coordinate bench, then it is a different matter. You have seen the judgments.
Lordship,
Huh?
Lordship may pass the judgment as in.
All right. Heard. Disposed. We'll pass orders.
Apply.
Item number 24, I missed it.
No, we just passed it over, I think. Take it up, item 24. Or if you want, we can take it up on some other date.
Only just, there was order for dusty service and dusty service that we have thrown, we have filed affidavit.
Dusty service you have undertaken.
Yes.
You have filed an affidavit to that effect.
Yes, but the respondent has not appeared, my lord.
All right, we'll give them another opportunity.
Yes.
Mr. D. Chaudhary, learned counsel for the petitioner, submits. আগত এটা লিখিছিলো, none appears, passed over. Who submits that in terms of The earlier order dated 21/12/2023 dusty service was affected on the respondent, namely the Assam Gramin Vikas Bank. Stop. He has submits that an affidavit Have you filed any affidavit? Have you filed an affidavit?
Yes.
An affidavit has been filed by the What is the date of your affidavit? We are unable to find it here.
Page 71,
Huh?
in the report. Paragraph 2.
Yes, has been filed on 18 January 2024. By the petitioner. To that effect, that dusty service has been undertaken on the respondent bank. Stop. However, none appears for the respondent bank in spite of dusty service being undertaken. Let the matter be listed after 1 week.
The date may be fixed on 5th of February.
5th of February.
Yes.
Let the matter be listed again on 5th of February.
This is a lot. Can it be adjusted for the time being, my lord?
Huh?
Can it be adjusted for the time being, my lord?
Time being.
Time being, my lord. On behalf of the HRH, I am taking this care, my lord.
Time being.
For the time.
So like my difficulties, my assisting counsel MS Bhattacharya, my lord, she has got some personal difficulties, she hasn't come to court.
Oh.
And she has prepared certain things, that is all, those are also with her. It will be on Monday next, my lord.
Monday next. Monday next is 29.
Yes, ma'am.
All right, 29th.
Well,
As
30, but let it be on 29th.
29th as jointly requested. As requested by Ms. Learned Additional AG and not objected to by the counsel for the petitioner. For admission.
Ma'am, keep your left.
Ma'am, as far as the telephony instruction process is going on to pay in district level, madam, kindly give some time.
Process is going on where?
Yeah, and district level, madam, as per telephony instruction.
My lord,
Uh,
this matter was filed on 14/12/22. Then 8 weeks time was there. Now 1 year, 1 month passed. Nothing replied. Thereafter, one order was passed on 18/9/23. The respondents were asked to appraise this code when they will pay the amount. For 10,000, 20,000, 26,000, 36. 4 years kept pending. The list of the payment and the teachers made at page 61 on additional affidavit. 10,000 rupees for more than 4 years can be kept without any reply.
you give us a fixed date. Give us a date. Don't say some more time. You tell us what steps have been taken. Who has given the telephonic instruction?
Always they ask for instruction.
Who has given you the telephonic instruction?
does nothing.
Official of district director.
Huh?
Official of director elementary education.
Director of
Elementary education.
elementary education.
Office assistant, my. So my lord, can you give 2 weeks?
No, no, not like this. Don't be casual in, if they don't have instructions, we'll pass orders. You ask them to obtain the required instructions. Several opportunities have been granted.
Yes.
We are giving you one final opportunity. You tell us what is the status.
Yes.
Otherwise, we'll proceed with the matter.
Okay.
One final opportunity, we'll grant them.
Last time it is that.
2nd of February.
Right.
Let it be on 2nd of February. The Learned Standing Council Elementary Education submits that the proposal for area salary is
It's 61. 60 to 63.
is presently being considered by the department by the appropriate authority in the department. He has prayed for accommodation. He has prayed for further time to complete his instructions. Top Mr. A.R. Medi, PCR Medi, Learned Council for the petitioner, strongly objects to the prayer made by the petitioner, by the respondent. He submits that on several occasions, opportunities were granted to the respondents, but on every date, adjournments are being sought for. Considering the submissions at the bar, this court is of the view that for the ends of justice, one final opportunity is granted to the respondent elementary education department to furnish their instructions to the council representing the department. Stop by the next date fixed. If the instructions are not placed before the court may proceed to pass orders on the basis of the pleadings available on record. Let the matter be listed again on 2nd of February.
2nd February.
No.
May I please, Lord? Well, this is an unfortunate case, Lordship. Despite of having interim order, no pension has been released, even the Lordship provisional pension. I am saying, Lordship, this matter may be discussed at court itself. Because the petitioner is not providing the pension on the ground that petitioner has not completed the qualifying service of 10 years. In fact, Lordship, the petitioner joined in service in 1996, and his service was regularized with effect from 1/6/2013.
Yes,
My lord,
pleadings are complete.
My lord, affidavit they have filed, and if your lordship kindly come to their affidavit also, the facts will clear. That is paragraph, lordship, 12 and 13. 11 and 12, lordship. And take page 88, running page, lordship. Paragraph 11, lordship.
Yes.
That with regard to the statement made in paragraph 8 and 9 of the writ petition, your humble deponent beg to state that the petitioner Sri Ranjan Nath, along with 50 other employees, there were, lordship, total 51, in the cadre of grade 4, tax collector and LDA were appointed by the then Director P&RD Department, Assam, on ad hoc basis in the year 1996. Against, lordship, sanctioned vacant post created by letter number so dated 17/2/1993 in Gaon Panchayat, Anchalik Panchayat, and then Mahakuma Parishad. The term of appointment of these employees were being extended for a period of 90 days from time to time until the service of these 51 ad hoc employees, including that of the petitioner, were regularized by government notification number so dated 1/6/2013. The petitioner was regularized on 1/6/2013 with effect, that is after 1/2/2005, who is as per government notification number so and so, would place the petitioner under the new pension scheme. It is observed that out of these 51 employees, your lordship, this is important, lordship.
Hmm.
GPF account, out of these 51 employees, GPF account has been created in respect of 10 employees. Whereas NPS account have been created in respect of 32 employees. Meanwhile, the remaining 9 employees have neither GPF nor NPS account. It is pertinent to mention here that the Commissioner PNRD by letter dated so and so had requested the CEO of the concerned Zilla Parishad to submit clarification as sought for by the government in the PNRD department by its letter dated so and so in respect of the 51 employees working under Panchayat and Rural Development. Accordingly, the CEO Kasar Zilla Parishad by letter so and so submitted the necessary clarification wherein it is stated that the office of the CEO Kasar Zilla Parishad had applied for opening a GPF account for the petitioner by forwarding his GPF application to the Accountant General Assam, white letter dated so. However, the office of the Accountant General had not proceeded with the same, and as such, the petitioner Sri Ranjan Das has neither been allotted GPF number nor NPS number. Hence, the office of the Commissioner has only sanctioned leave encashment, white number sales. Paragraph 12. With regard to the statement made in paragraph 12, so your humble deponent respectively submit that considering the fact that the petitioner was regularized on 1/6/2013 with immediate effect, that is after 1/2/2005, which as per government notification dated so would place the petitioner under new pension scheme, and the fact that the petitioner has neither been allotted TPF number nor an NPS number, the office of the Commissioner PNRD department has requested the government in the PNRD department to provide guidance for taking further necessary action in respect of the petitioner. Further, it is stated that since the petitioner was regularized after 1/2/2005, the ad hoc period cannot be considered for pension and pensionable. Why not? The period which lordship he has rendered lordship under ad hoc period, that was lordship for 17 years, 17 days. And during after regularization lordship, he has completed 7 years, 9 months, 30 days. Well, there are taken up the decision of our High Court as well as the Honorable Supreme Court lordship that for lordship pension, the ad hoc period should be taken into consideration for qualifying period for pension lordship.
No, you were appointed on which date?
My lord, appointed on 18/3/1996.
18/3.
1996.
Tempered.
Temporary. That
But
is
regularized on 1/6.
1/6. And without any break lordship, I continued to work and the lordship against a valid sanction.
Where is your regularization order?
My lord, that is regularization order. Your lordship will find page 57.
57.
My name appear at serial number 48. And last 2 lines of page 58. The post were originally created by government letter number so and so, dated 17/2/1993 and last retained up to so and so, so and so. These were lordship against valid sanction post. An initial appointment of the petitioner, that means your lordship may turn to page 18.
Yes.
Page 18, this is the initial appointment for 90 days. Ranjan Nath so village so is temporarily appointed as tax collector for a period of 90 days. That is so with scale of pay of rupees so plus other admissible allowances under the rules and place his service under the subsequently his service was extended. I have annexed some orders. Lordship without any break lordship he continued. And after that lordship his service was regular. But I am relying some decision.
What is some substance of the affair stand by the department? What have you stated?
Within para 7, that well, considering the fact that the petitioner was regularized on 1/6/2013.
We are reading para
12 months.
12.
Considering the fact that the petitioner was regularized on 1/6/2013 with immediate effect, that is after 1/2/2005, which as per government notification number 2020, would place the petitioner under the new pension scheme.
But he has not been allowed uh, he has not been given NPS number or GPF number and all that. Why?
Well, the person who were given the GPF, they are getting pension.
That was actually stand, but the Office of the Accountant General has not proceeded with the same manner. So now we'll have a look at para 11 towards the bottom.
You are the administrative department. Why are you shifting your responsibilities here and there? You tell us why the number has not been granted. And what steps have you taken?
It had been applied for, madam, before the Accountant General. The office of the CEO Kasar Jilla Parishad had applied for opening a GPF account for the petitioner for forwarding a GPF application to the Accountant General Assam. Providing letter number so and so dated 21/11/2013. However, the office of the Accountant General has not proceeded with the same. And as such, the petitioner, Sri Ranjan Nath, has neither been allotted GPF number nor NPS number.
Where is that letter?
This is matter at page 89. The
Letter. Copy of the letter.
would be at Annex 2, madam. Page 93.
This is the letter to the commissioner. Who's for the AG? AG is a party here?
But AG is not party located in
Then how do we find out what steps have been taken in this letter at page 94? You call for the Accountant General Council. Let us find out. Please intimate him. We'll take it up after a while. At a very providing Standing Council Accountant. Article 31.
Item number 31, my lord.
The file they're searching for it. Yes, 32.
May I please your lordship, madam. Inspection was called for from the respondent number 2 and 6, madam. 2 is Director of Elementary Education, 6 is District Elementary Education Officer.
Yes, no instructions.
My lord, as per instruction, all service, original service books are with the pension department, my lord.
Original what? Service record.
Yes, ma'am. Service book regarding benefit of financial upgradation under MSCP. Minimum is required. It's pension department, ma'am. As per instruction. After
Who's for the
issue-
pension department?
I have the instruction.
What is that?
Accountant General.
You are for the accountant general. No, he says it is with the pension department. Who's for the pension department? Any instructions here?
No, my lord. My lord, this MSCPS that is to be decided by the department, my lord. Now, since we have come to know that the records are with us, my lord, so let me obtain the instruction, my lord.
All right. There is some instructions. What is the name of the petitioner?
MD Iman Ali. Petitioner was retired on 31st 12/2019, my lord. One benefit was not received, my lord. That is under benefit
What,
of
these instructions pertain to some other matter? What are you submitting? Yes, Mr. Pegu, get your instructions. Find out. Let him get the instructions. Your service book is supposed to be with the
Yes,
department.
my lord. Fix the date, my lord. Otherwise,
At the request of the counsel for the Department of Pension, let the matter be listed after 2 weeks, enabling him to complete the instructions with regard in respect of the availability of the service book of the petitioner with the pension department. Let the matter be listed after 3 weeks. Mr. Learned Counsel appears for the petitioner. Yes, what instructions have you got? No. List after 3 weeks.
fix the date. Fix the date.
You want a date?
Yes, my lord. Otherwise, no list.
26th of February.
Always.
Your Lordship. In spite of taking time for filing affidavit, Your Lordship, they have not yet filed affidavit. The Department of Higher Education, Your Lordship. And on the last occasion, on 8/12/23, they are directed to positively file, Your Lordship. Yeah. In this case, Your Lordship,
My lord, I am appearing for higher education, my lord.
Yes.
My lord, this matter has been, my lord, was looking by new comment, my lord. So, my lord, most probably, my lord, kindly fix the matter next week, my lord. He is out of station, my lord. So,
See, these kind of submissions are not to be made on behalf of standing councils.
I know, my lord,
Unless, no, if you know, then don't make a submission. This is not the way to make a submission. It is looked after by so and so. He does not have it. This matter pertains to the department. This is not a parted matter.
affidavit will be required, my lord. So
If
that's
it is
why I'm
required, you
seeking,
file
sir.
it. If it's not required, you don't file it. But this is not the submission to be made that so and so is looking after the matter and he is not available. This is the parted matter. That is the reason why you have a number of standing councils.
Kindly
So
some
that
time-
if one is not available, the other should fill in.
Some time may be given, my lord. file it, because instruction is still awaited.
Who is supposed to give you the instructions?
My lord,
Director of Higher Education.
Director of Technical Education, my lord.
Higher Education.
Higher Education, Technical. The technical department.
One thing is that, your lordship,
Why is it a technical education? It's
Higher
not a technical education.
higher education.
Higher Education.
One thing is that, your lordship,
Hmm.
the petitioner returned on 30/11/2019, and after in person
What
to
is,
the-
what according to you should be a provisional pension?
at least 50% of the last.
On what basis are you saying it?
Your lordship may kindly see Rule 22(1), your lordship.
Uh,
Though the percentage is not given, your lordship. Rule 22(1) of the pension, account pension rule.
22,
22,
yes.
sub rule 1, where any departmental or judicial proceeding is instituted under Rule 21, or where a departmental proceeding continue under clause A of the proviso thereto against an officer who has retired on attaining the age of compulsory retirement, other he shall be paid during the period commencing from the date of his retirement to the date on which, upon conclusion of such proceeding, final order of pass, a provisional pension.
What
not
is
a
your
fixed-
pension? What would be your full pension? According to you? What would be your regular pension?
Regular pension will be determined on the basis of the last basic pay, that was 1,87,300 euros
Hmm.
plus DA. It will come.
And what is the amount that is being paid to you?
Only, your lordship, 27,500, your lordship. Page 67, your lordship. Page 67. At least it will come to 93,650, your lordship.
Have you made out this calculation here?
Yes, your lordship. In para, stated one, what basis they have allotted 27,000, your lordship? You will have to answer, your lordship.
Hmm? No, no,
On
you first show us what is the para 12.
Para 12, page 12.
Okay, heard Mr. R. Mazumdar, Learned Counsel, appearing for the petitioner. Mr. S. Borwa.
S. Das, my lord.
S. Das, Learned Counsel, appearing for the higher education.
Yes, my lord.
Anyone else?
AG is there, but AG has at present no role, your lord.
Okay,
Already,
Mr. R.K. Talukdar for AG, Mr. Pegu for pension. Who is for the college? Mr. Borpuzari for finance. Stop this. In this matter, notices were issued on so and so date, enabling the respondents to respond, complete their instructions and file affidavit. 23/8/2023 notices were issued. Thereafter, several opportunities were granted. However, the respondents have not been able to complete their instructions or file any counter affidavit responding to the challenges made in the present writ petition. Stop. It is submitted by Mr. Mazumdar that he is entitled to a regular pension of rupees 187,300 as per his calculation. No, sorry.
no, this was the last pay.
His last pay was 187,300, and therefore his pension ought to have been calculated at 50% of the basic pay, which comes to about 93,650. Stop. However, his pension has not been released, and in the meantime, the petitioners, the respondents have allowed the petitioner, have sanctioned only a provisional pension of rupees 27,500 per month. Stop. Let the matter be listed after 4 weeks, enabling the respondents to complete the instructions and file necessary affidavit if so advised. In the meantime, the provisional pension will be enhanced to 50% of the pension, regular pension payable, to be released immediately. Let the matter be listed after 4 weeks. A copy of this order be furnished to the no, it's represented by standing council. So copy of the order be furnished to the office of the, what is that, standing council?
Standing council.
Higher education for onward communication. Yes.
Lordship, the area salary proposal has been submitted to the office of the secretary for necessary sanction by the director, Lord.
Sanction.
Proposal has been sent to the
Sent.
secretary, Lordship, sent already on 22nd of January next month. Yesterday.
Pursuant to the now, in terms of the earlier order dated 8/12/2023, wherein it was recorded, wherein the submission of the standing council, elementary education was recorded, that the proposal for area salary of the petitioner to an amount of rupees 27,76,080 has been received from the DEEO Lakhimpur, and the same, if found correct, will be forwarded to the government for sanction, it is submitted today by Mr. P.N. Sharma, Learned Standing Council, Elementary Education, that the proposal has been forwarded to the secretary.
To the secretary on 22nd of January.
What is that? Secretary Elementary, School Education.
Department of School Education.
Department of School Education for necessary sanction. On which date?
On 22nd of January.
Forwarded to the secretary's office on 22nd of January.
Lordship.
That is yesterday.
Yesterday, Lordship.
Oh. So, under such circumstances, the Learned Standing Council submits that matter be listed after 4 weeks. Mr. Purukashta, B. Purukashta, Learned Counsel for the petitioner, appears for the, does not object to the prayer made. List after 4 weeks.
Any date valid after 4 weeks?
You mentioned it if required. 4 weeks on a date to be fixed by the registry. Yeah.
But in this case, my lord, all the benefits has been received by the petitioner.
The
matter has become now in progress.
Okay. It is submitted by the Learned Counsel for the petitioner that what benefits were you asking for?
The non-payment of family pension.
The
And death
family
benefit.
pension payable to the petitioner has now been released, and the petitioner has been receiving the family pension. He therefore submits that the writ petition may be closed. MS so-and-so appears for the
Sericulture.
Sericulture Department. Mr. C.K.S. Borua for
Pension Department.
Pension Department. Accordingly, writ petition stands closed as not pressed. Interim orders, if any, will stand vacated pending IS disposed.
My lord.
Mr. Corpusary for Finance.
My lord.
Yes. You are for Accountant General. Record the name. You see, what has happened is there is a statement, averment in the affidavit of the respondent department that a proposal has been sent, not proposal, communication has been sent to the Accountant General regarding GPF. This was sent in as far back as 21st November 2013. But department says we have not received any information. So since it is the Accountant General, we thought you might like to update the court about what is the present position. Have you been served with a copy? You serve him a copy of the petition as well as the affidavit.
Lordship, today itself I
Heard learned counsel for the parties. During the course of the hearing, it is seen from the affidavit filed by the PNRD department that the GPF application of the petitioner was forwarded to the Accountant General's office as far back as 21st of November 2013. However, no response has been received from the office of the Accountant General. In that view of the matter, this court requested the Standing Counsel Accountant General, Mr. R.K. Talukdar, to obtain the required instructions and place it before the court, notwithstanding that Accountant General is not a party respondent in the present proceedings. Stop. In the event this court feels that the Accountant General ought to be arrayed as a party, specific orders may be passed by the court. Place the matter on, give us a date.
After 2 weeks, Lordship.
After
or
2
10
weeks. Mr. Khan will furnish extra copies of the pleadings to the Standing Counsel for enabling him to obtain the required instructions as directed by the court. Placed on 26th of February.
answer only on 6th of February. Lordship.
Huh?
Because petitioner is not getting Lordship even the provisional pen. Can it be on 6th of February?
বন্ধ হয় কেন? No. মাজতে এইবাৰ বন্ধ হয়। No. Lordship, second week of February, Lordship, any date.
15 February.
Obliged.
Lord, in terms of the early order, my lord, there was a direction to obtain instruction, my lord. Lord, I pray for some more time, my lord. There are still 9 petitioners, my lord. Petitioner number
Only one has not been given.
Yes, my lord. So to that effect, my lord, let me get the instruction.
Mr. Pegu Learned, G. Pegu Learned, government advocate.
My lord.
You are appearing on whose behalf?
Respondent number 3 and 4, my lord. Sanction.
Huh?
Respondent number 3 and 4.
3 and 4. Pension. Appear representing the pension department submits that further time is required to obtain the instructions as to why the pension to the petitioner number 9 has not been granted, although pension in respect of petitioners 1 to 8 have already been released. You are appearing for?
I am for respondent number 9.
Who is 9?
Tenant manager, quarter refinery.
Your name, please?
M. Gogoi.
M. Gogoi. Appears for respondent 9, MS Mushari for 1 and 2. Since the petitioner is not represented by counsel, prayer made is allowed with the matter to be listed after 2 weeks on a date to be fixed by the registry.
Monday.
Singhania.
Yes,
Tell us. Why is it not? It is not recognized.
Singhania cannot provide degrees through distance mode.
Why?
They are debarred from doing that. They are de-recognized.
With effect from?
Lord, This letter shows, my lord,
Hmm.
if I can read it once.
Yes, please.
This is a letter, kindly note the date, my lord, 10 January 2013. With reference to your letter number so-and-so dated nil.
Hmm.
On the subject cited above, I am directed to inform you that the UGC has received the Act number so-and-so of the State Legislature of Rajasthan, wherein Singhania University, Pacheri, Chunjunu, Rajasthan, has been established by notification number so-and-so dated 29/3/2008. In view of the establishment of the Singhania University so-and-so by the State Act, the name of the university has been included in the list maintained by the UGC on its website so-and-so. The inclusion of the name of the university in the list of universities maintained by the UGC does not by itself allow the university to make admissions in its programs. This may be done only after creation of required academic and physical infrastructure facilities, including library, laboratories, and appointment of teaching and supporting staff as per the norms and standards laid down by the UGC and statutory councils concerned. The university is now requested to submit detailed information in the enclosed format, along with supporting documents duly attested by Registrar of University within a period of 3 months from the receipt of this letter. The format is also available on the UGC website number so-and-so. After receipt of the information in the above mentioned format, the following procedure would be adopted by the UGC for inspection of the university. The information received from the university in the prescribed format would be posted at the UGC website within 10 days of the receipt of the information. Comments would be invited from the general public within 1 month thereafter about the information submitted by the university. The same information shall also be posted by the university on its website immediately. The comments received from the general public would be placed before the visiting UGC expert committee for perusal. An expert committee would be constituted by the UGC to ascertain whether the university fulfills the criteria in terms of programs, faculty infrastructural facilities, financial viabilities, etc., as laid down from time to time by the UGC and other concerned statutory bodies such as AICT, BCI, so-and-so, so-and-so, so-and-so. The UGC expert committee would visit the university within 3 months of the receipt of the information for on-the-spot assessment of the infrastructure and other facilities available at the university. The report prepared by the UGC expert committee would be sent to the university within 2 weeks of the completion of the visit of the comments. Rest are not required. What is my submission, my lord? This is the letter of 10 January 2013. Meaning thereby, till this date, the university was not ready to provide or confer degree to anyone. Now kindly see the degrees.
On what basis are you making this statement?
Pardon me, lord.
On what basis? You are asking the university to provide infrastructures,
Because this is the statutory requirement.
Correct, but there must be an order passed by the UGC that this university is not a listed university, approved listed
No,
university.
my lord, the universities are being floated by the state.
Exactly. But what is the purpose of UGC? To ascertain whether these universities maintain the requirements.
That is a second stage.
Huh.
Once, suppose, my lord, today the state of Assam has enactment a private university act or a state university. The moment it is enacted, it is not ready for disbursal of the degrees or or getting admissions of the student. The second stage is that university UGC officials will come for inspection and they'll file a report.
Once it is framed by statute, laying down that this is a university to be constituted.
My lord, the enactment of the state is just a proposal to float an university.
No.
To establish an university.
No, it is a statute by which the university is constituted.
Yes, university is constituted, but the day one it is not ready for disbursal because it needs.
Whatever it may be, but it is constituted.
It is constituted, right?
Now,
that is correct.
Once the university is constituted, it is expected to function.
It is expected, but not the second day it cannot run.
No,
because
second day, third day, we are not on that. We are asking you what is the role of UGC vis-a-vis
role of UGC to
vis-a-vis universities constituted by statute under a
yes,
statute.
I understand. My lord, the moment it is constituted,
as your lordship can see from this letter, UGC has itself said that we have received your act. That was enacted on 29/3/2008. We have received it. Immediately after receipt of that letter, that act, UGC will call for them for providing the information. Till 2013, they have not provided. That is why.
No, see, come to the penultimate paragraph of 5 and 6.
Yes, my lord. As per the judgment of the Honorable Supreme Court in the case of Professor Yaspal, there is no provision to have regional centers, off-campus centers beyond the territorial jurisdiction of the state. In view of the judgment of the Apex Court, the university is requested to adhere to the following. No off-campus centers is opened by the university outside the territorial jurisdiction of the state in view of the judgment of the Supreme Court. In case the university has already started any off-campus center outside the state, it must be closed down immediately. It may also be ensured that any off-campus center within the state shall be opened only as per the provisions laid down in the UGC Establishment Act 2000, Regulation 2003.
Now you come to 4G. 4G, previous page. 4G.
If it is found that the private university has, even after getting an opportunity to do so, failed to comply with the provisions of the various UGC regulations, including UGC Establishment and Maintenance of Standards of Private Universities Regulation 2003, and suggestions given by the UGC Expert Committee, the Commission may pass an order prohibiting the university from offering any course for the award of the degree and or the postgraduate degree diploma, as the case may be, till the deficiency is rectified.
So has any order been passed?
No,
by
my
the
lord,
UGC?
what I'm trying to show to your lordship by showing this letter is, till January 2013, this university was not ready to offer degree because of non-completion of those formalities. And in the instant case, the petitioner, Dr. Archana Gogoi, she has obtained, she had taken admission, if your honor, my lord can see.
No, when was the degree given? When did you get your degree?
She got the admission in page 29, my lord.
Yes.
In page 29, this is the provisional registration for PhD degree dated December 16, 2009.
29 is Ajya Vidyapith College.
No,
No,
Dr. Archana
Huh?
It is my lord.
6540 Talisha.
Okay. Next case.
Next.
– 6540. Page 29, my lord.
29.
This university was established on 29 September 2008. And she took admission for provisional registration for PhD on December 16, 2009. In my respectful submission, the university was not ready for disbursal of any degree till 2013.
No, but there has to be a finding by the UGC to that effect. You are a body,
statutory
body supposed to lay down standards.
My
You have issued a letter that has not been complied with.
My lord.
Or some university has come into existence. Now, what steps are you
My lord,
required to
we
take?
are taking steps by steps, my lord, because the universities and institutions are the direct control of the state. We need to monitor and regulate the standards only. The constitution, whether it was properly constituted or not.
The issue here is that there is a degree obtained from some other state by a person who's domiciled in some other state in the same country. The department has rejected their degrees by saying it is from that university.
No, not on that, my lord. Department, to my understanding, department, I may be subject to correction, my lord. Department has rejected the PhD degree only because that it has been taken on a distance mode. Singhania University, I will come up on with an affidavit, my lord, on oath, I will come up. Singhania University has never been authorized to dispense with degrees for offering degrees through distance mode. And off-campus, my lord, even if that, presume it for a moment, my lord, that the university is ready for disbursal of degree or conferring degree, even then, my lord, off-campus is not at all permissible.
Where is that Your affidavit is already there on record.
My lord, I am sorry, I was supposed to pray, my lord. This was an affidavit filed by mistake. This affidavit is was for some other cases. It was wrongly typed and I also, my mistake, my lord. I apologize, my
You
lord.
can't file an affidavit and
Right,
say
right,
for-
Lord.
it is by mistake.
My lord,
It is
due
an
apology.
affidavit sworn on oath.
My lord, I apologize. This was a mistake on I don't know, now I have to shoulder the responsibility. The affidavit I prepared and sent it to Delhi was not sent. At the time of filing, I did not recheck it, my lord. That is the problem. I sent something else. I sent a very detailed affidavit.
We don't know. We'll go by
I
the
understand,
affidavit.
my lord.
which is
How
available
court
on-
will know? My respectful submission, my lord, I may be allowed to withdraw that affidavit.
No, you can't withdraw an affidavit like that. How can you withdraw an affidavit?
My lord,
File on oath.
no, my lord, I will, if
Whatever
necessary,
you may say, you may supplement it is a different issue.
No, no,
But
my
how
lord-
can you withdraw an affidavit? File on oath
my lord,
and file something completely different?
no, my lord, it's a technical error, my lord, or inadvertently it was filed.
It is not to be taken so lightly. It's an affidavit on oath.
No, my lord, I
Whole-
understand, my
whole
lord.
proceedings of-
Affidavit-
before this court proceeds on oath.
No,
There's no
I
evidence.
I agree to this, my lord. The
Then-
only thing that it is an inadvertent mistakes, my lord, and I'll file an I for seeking a permission, my lord.
Where is that order by which your degree has been rejected?
My lord, till today, not rejected, my lord. And it is, my learned friend submitted that it is a distance mode. No, it is regular mode, my lord. She pursued her PhD degree.
In regular mode, my lord,
Yes.
in regular mode PhD degree, he cannot have a guide in Assam, my lord. He has to have a guide from that university. This is the constant,
No affidavit is filed by the respondents here. Education department.
In 20,
In which
in
item?
second case, it is filed.
Second case.
Archana file question.
6543, madam.
Huh?
6543.
654.
In the departmental affidavit, my lord, page 66, my lord.
নহয় এইটো ভুলকে লিখিছে আউটসাইড দ্য ষ্টেট অফ আসাম হলে নহব নেকি অফ কেম্পাছ হলে নহব ডিষ্টেন্স মোড হলে নহব এনেকে লিখিলে নহব ন
He come to page number 76, para 10 of the affidavit, state affidavit.
মই চাওঁ
That is what has been stated by the government sub-para. Is not considered as the same as obtained by the writ petitioner from so-and-so university, which is outside the state of Assam.
Perhaps this is not the correct legal position, my lord. It may be from the state of Assam, outside the state of Assam, my lord, but it cannot be on a distance mode. That should have been the stand, my lord.
What is the distance mode?
Distance mode, this is correspondence course like.
It
Distance
cannot be
mode
done.
means
No. As far as the Professor Yashpal
Is
judgment,
concerned.
subject to correction, is that you can have it, but your centers, the examination centers can be in
different states.
different states.
Yeah, that is the thing.
So,
He has to go there, appear examination, take classes.
but there is no bar for,
Not bar at all.
no bar for online.
Through distance mode, 2 degrees cannot be conferred through distance mode. One, after 2005. One, 2005 means after Professor Yashpal. One, that is MPhil. Second, this is PhD. Then in 2009, MPhil PhD regulations came on July 2009.
Okay. You bring on record.
My
your-
lord, I'll file a detailed affidavit. If Lordship allows me to withdraw that, my lord, I'll withdraw the.
We'll decide that later. But first you get your affidavit, whatever you want to file an additional affidavit, you file it on record.
My lord.
My lord, Supreme Court recent judgment is also, my lord.
Oh, we'll come to judgments later. First, tell us the facts. You have not been able to lay down the facts
Lord,
properly.
Can they file
Have
a,
you shown us the regulations of the UGC? Is it on record? UGC regulations?
No, my lord.
No.
It is.
Is it your case that this is the statute?
Enact,
Mr. Counsel, your university is by statutory act of a state.
my lord.
Is it your case that it is a statutory act, UGC has no role to play, therefore it can't de-recognize my degrees? Have you shown us the statute by which the university was created? What was there? Nothing. You go straight to the judgments. Judgments are rendered on facts of the case. You first urge the facts. Have you replied to the state affidavit?
My lord. No, my lord.
No. There is a categorical averment that your degree is not recognized because it is from outside the state. You have not responded to that affidavit. Is your case, you are before the court urging, what orders do you want the court to pass like this? Matter deferred for 4 weeks, enabling the parties to exchange their affidavits, the pleadings. The UGC will also place before the court the regulations / the guidelines / the rules which are for a regulation or supervision of the universities and the degrees conferred by such universities. List after 4 weeks.
My lord, a date may-
No date. For what purpose we fix a date? For hearing the matter.
My lord.
We can't hear the matter unless you complete the pleadings, complete your instructions on facts.
May I point out? A High Court company has already verified that it is in 2019. That verification result may kindly be called from the court.
if it is there,
It is in 2019. The High Court.
Department, the kind of affidavit they have filed, I don't think we should even direct them to do anything.
I filed as per instructions, my lord. As per instructions, my lord, I filed.
No, instructions may be given anything, but you are a counsel, you are an officer of the court. Instructions could be anything.
And I can't
But you'll have to decide whether these instructions should go in the form of an affidavit or not. If not, you call for fresh instructions. Merely because there is an instruction, you want to put it on an affidavit. An affidavit sworn on oath by an officer of the department that it is a degree from outside the state, therefore it cannot be recognized. What kind of a statement is this? They have given it to you and you are the counsel. You have to decide whether this is fit enough to be put in an affidavit before a court.
My lord, if required, I will.
We are not
additional-
we are not proceeding in a village panchayat.
My lord,
This is a
I
court
understand.
proceedings, constitutional court.
If required, I'll file additional affidavit.
We don't know if required or not. We are given liberties. You file it.
My lord.
I think now we'll have to pass an order that all affidavits should be vetted through your senior government advocate's office over all departments. This is highly irresponsible, if I may say so. Yes.
May I please, Lord? Lord, this application is filed for modification of the order lordship, that is case 9 lordship is start 9 and 11 lordship is 11. But by this order lordship, we are the petitioner in the petition. By this order lordship, the impugn order has been stayed. And one restriction has been imposed. It is however lordship page 11. Lordship.
Yes.
It is however made clear that the process before that lordship in the interim, the order dated 07/07/2023.
Oh, educational tribunal.
My lord. That
Okay.
has been suspended. It is however made clear that the process of recruitment of principal of College of Education, Boko Kamru, pursuant to the advertisement dated.
What is the direction of the education? What was the finding of the education tribunal?
Termination order of the principal, that was, that is state lordship, that is in case lordship 73 in the requisition lordship. termination order of the principal has been issued with a direction to the college authority not to appoint the principal. That
Page
is
number
page 73,
73.
my lord. And relevant is lordship at page 77. Last paragraph, lordship. Accordingly, issue should cause notice to the opposite party as to the prayer made by the petitioner shall not be allowed. And in the meantime, till Shukas reply is received from the opposite party number so and so, opposite party numbers so and so are restrained to give effect to the
The
termination.
matter is still pending.
My lord,
Matter is still pending.
Yes.
Before the tribunal.
that has been stated. Because lordship tribunal has no jurisdiction because this is a private college and a petition was filed under section 19 of the Provincialization Act 2017. That is not maintainable, lordship. Accordingly, this honorable court lordship has stayed the proceeding and lordship with a direction not to finalize the selection process, lordship, of the principal. But what happened, lordship? In the meantime, the private respondent, lordship, who has been terminated, she has already been appointed in another college, lordship. That is your lordship will find at page 13 in my IA. Page 13 in my IA, lordship.
Yes.
My lord, CA number 1, lordship, Mary Chaudhary.
Hmm.
My lord, this is the documents of Lakhimpur College, lordship. She has already been appointed as a HOD, lordship, on 25, lordship, in the last column, lordship, joining date, 25/1/2023.
Hmm.
Before her termination, lordship, she joined there. Thereafter, lordship, there irregularities are there in the college. Accordingly, lordship, with due procedure, she was terminated. Now, Lord, my humble submission, lordship, as she has already been appointed, lordship, the college should not be suffered, lordship. Let the college be appoint the principal, regular principal, and that appointment may be subject to outcome of the writ petition.
Who filed the writ petition?
We filed the writ petition. The
You
college,
filed the writ petition.
my lord.
Praying for?
Only seeking lordship leave of this honorable court, lordship, that is case in- seeking leave of this honorable court to appoint the principal, lordship.
Appoint the principal.
Principal of the college. That may be subject to the outcome of the writ petition, as she has already been appointed in another college.
But it is at your case, the interim order, at your instance, the interim order has been passed.
No, I am not in the lordship, in the stay order, suspended part, lordship.
Huh?
Suspended that impugn order of the tribunal that has been suspended. That was lordship with condition. It is however made clear that the process of prescription of principal of College of Education so and so, the advertisement records will not be finalized without the permission of this court. Now, lordship, we are praying for permission of this court to appoint this principal.
Yes, what do you say?
Your Lordship, I have already joined your Lord in the college
Hmm.
because he was terminated me
Hmm.
from the service, your Lordship. And so having no alternatives, I have joined in the Lakhimpur College, your Lordship, not on 25/1, but I joined on 22/9/2023, your Lordship, my affidavit.
Hmm. So you are no longer contesting for the principal post?
No, I will contest the principal post.
Okay.
I have already been before the tribunal, your Lordship, and here also.
Okay.
I will contest.
All right.
So my humble submission, your Lordship, I have no alternative at that time. So I have to go somewhere, your Lordship. But I am still contesting the principal post, your Lordship. And moreover, your Lordship, my humble submission, it may fix for admission hearing, your Lordship, the man. Let it be, let it be, your
He
Lordship.
has already been
Because
appointed.
the order was, that
No,
is the
no,
order was,
her appointment is what, as a principal?
No, yes,
HOD, your
lordship,
Lordship.
HOD, and she is contesting in the matter for the post of principal.
That can be, she can contest this.
Ah,
case,
then-
my lord. My lord, my humble submission is that let the college authority be appoint the principal, and that appointment may be subject to the outcome of the writ petition. No harm comes to her, lordship.
Yes.
my humble submission, your Lordships, I am opposed to this, your Lordship, because the order was passed on his insistence. Is there, your Lordship, the first order, your Lordship. So my
On
humble
his
submission-
submissions.
The first order of the writ.
What is the first order?
Yes. In the writ, your Lordship.
Yes, 11, 10, 11, and 11.
In the writ, your Lordship.
Yes.
So my humble submission, I am contesting this, your lordship, because I was wrongly terminated by the authority, your lordship, college authority. My humble
No,
submission,
that
I
is what we are asking you. This order was passed at the instance of the petitioner.
your lordship.
Then, now why do you want to?
Well, look, there are two parts of the interim order. Lordship. That part, lordship, so far the second part is concerned.
Two parts I can see,
Lordship.
but as whose instance this order was passed? Who prayed for this order?
My lord, we prayed for a stay of the order, lordship.
Huh.
This honorable court, lordship, has imposed one condition.
Huh.
That is, lordship, I want to, lordship, lordship, clarify that position, that modify that condition, lordship. Seeking leave of
No,
this
then
honorable
it has
court.
to be placed before the concerned bench. We cannot. This is an order at your instance.
My lord, what happened, lordship?
We understand what happened, but this is an order at your instance. This is ex parte the respondent number 3. Only the counsel for petitioner and Guwahati University was present.
My lord, this, so far the second part is concerned. That was not at the instance of the petition.
So therefore you have to urge this before the concerned bench.
My lord, what happens after passing this order, lordship, this, we have got this information that she has already been appointed. That's why, lordship, we filed this petition. for
There are two
modification.
different things again now in your submission.
My lord.
Number one is whether you made the submission, and now having made the submission, you have realized now or come to have been informed later that the respondent 3 has been appointed.
Yep.
This is one situation.
My lord.
The other is, which you first submitted, is that there was no submission on your part in respect of this last part of the order. These are two different compartments.
My lord, this part.
Which compartment, which submission did you make before the court on 28/7? You were present, assisting a senior counsel.
My lord, we were present, lordship. At that time, lordship, we did not oppose because she
So
was waiting for that.
you admit that you made this particular submission. On your instance, this order has been given.
My lord, that was, lordship, so far the first part, lordship. That is the stay of the impugn order, lordship.
We are asking you a very simple
Madam,
question in a very simple, in my opinion. If you are unable to understand the query of the court, tell us, we'll repeat it again.
My lord,
What did you submit before the court?
my lord, our prayer was to stay the impugn order.
Right.
That has been stayed
Very good.
with a condition.
Now
that-
you want to say that this last part was given by the court itself,
My lord,
not at your submission.
that was, lordship, actually not, lordship, at our instance, lordship. But that part has been added by this honorable court, lordship.
By the court, not at your submission.
I don't know. It was not our submission, lordship.
You're sure? We'll record it. We'll record it. Because in that case, it has to be placed before the concerned bench.
But that may not be recorded because at that time, lordship, senior counsel Ikenayar was there, lordship. Well, may I pray, lordship, because after that, lordship,
I'd learned counsel for the parties, matter be listed for hearing. Any appointments made to the post of principal shall be subject to the outcome of the writ petition, and the rights of the respondent number 3
Well.
for her claim to the post of principal of so-and-so college shall not be the rights of the respondent number 3 will not be prejudiced by her joining her service in HOD in what? Sripsagar College?
My lord,
Lakhimpur College.
Huh?
Lakhimpur.
Lakhimpur College.
not looking to.
Not Lakhimpur.
Lakhimpur College. Any appointments which are made shall be subject to the outcome of the petition, and such appointments shall not be confirmed without the leave of the court.
We want to give appointment.
You give appointment, but don't confirm, because the writ petition is pending.
My lord,
To that extent, the interim order passed on so-and-so 28/7/2023 stands modified. IA disposed of, and writ petition be listed for hearing.
Hello? process has already been completed, only just to issue appointment order.
We had modified it, allowing you, but don't confirm without leave of the court.
My lord, that's it.
Yes. No.
Make these lordship.
Hearing matters, any counsel appears for the hearing matters, 1 minute. These matters will be listed in part 2.
My lord, item 38 maybe, my lord, infractions matter, my lord.
Item 38 infractors.
My lord.
At the request of Mr. So-and-so, learned counsel for the petitioner on instructions, the writ petition has become infractuous. Writ petition dismissed, interim order, if any, stands vacated, pending I is also dismissed. Yes.
Item
Only obliged,
37,
my
Your Lord. This
37.
matter has also become infectious. My lord.
Item 37, similar prayers, similar order. Yes. 37.
37.
Yes, all right. You're Mr.
M. Pandit.
M. Pandit, learned counsel. Yes. Mr.
R.K. Talukdar.
R.K. Talukdar appears for
Rest
Accountant
number
General. Accountant General.
My lord, item number 42, this matter pertains to family pension, my lord. Any other day, my lord.
No, we are directing these matters to be listed in part 2. It will be there on any date. There is time, you make a mention, we'll take up these matters for hearing. Instead of listing it on a day-to-day basis, let it remain in the part 2, so that we don't have to pass orders fixing these matters every day.
Obliged, my lord.
All right? It will be effective from maybe immediately after 26th.
Lordship, item number 41, Lordship.
Hmm.
Lordship, Senior Counsel James Sahavala sir is there, Lordship. He is not well, Lordship. Already concerned.
You inform the other side, it will be listed in part 2.
My lord.
Yes.
Regarding item number 49, supplementary list. It is a hearing matter. It is a pension matter, my lord. Your lordship has fixed the date again and again, my lord, but they have not.
All right, 49 will take it up just now. Yes.
Today, my lord.
Yes, just now. Yes.
44 also, petitioner before lordship is a widow lordship. He has done receive pension lordship.
No, we just repeat whatever we said. All these are hearing matters will be listed in part 2. Part 2 matters will be listed for, say, 1 month at least. And you will have liberty to mention the matters before the court to get it done. Instead of listing it in part 1, we are transferring these matters to part 2 to be taken up on every day, subject to permission, time being granted.
Family pension matter.
Yes. It will be in part 2. You make a mention when it is get listed in part 2 matters. Okay? Yes.
Well, please, Lord.
Yes.
I am appearing item number 45, Lord. Lordship, matter may be taken up today.
Not today. Why?
Matter relates to family pension. Lord.
It will come in part 2.
We have not.
It will come in part 2. It will come in part 2. We are in the middle of a parted matter. Yes.
Same 45.
Yes. 45. Yes. 49. So just one more matter. Item 49. Yes.
Can it be taken after?
He was here. He made a mention. Where is he gone?
He is on outside. I will call him.
Huh?
He is on outside. I will call
We just told him we'll take up the matter just now.
you after some time.
No, after some time. Gets deferred if he's not here.
This matter pertains to family pension matter.
Use for the respondents here. PWD. Who's for PWD?
Last occasion, asked the Pension and Public Grievance Department regarding the office notification.
Which office notification?
There is an office notification, my lord. They stated that pension will be due from that, the date of that notification, my lord. It is their affidavit.
Page number?
खुलीला नहीं. It was by reply of the AZ.
Page number.
Yes, my lord. It is at page number 49 and extra C. That affidavit was we have received on 21/9/2023. It is the last affidavit filed by AZ.
Then? No, you are referring
My
to
father was died on 28/2/1988. I am substituted by an order. I have paid for family pension that was released by PPO number. But the effect date was from the date of 25/2009. That was the effect date. But
how old
actually,
are you? How old are you? How old are you now? What is your age? You are
my lord,
the you are the
it is
you are the wife.
area pension.
You are the wife.
I am wife.
Then why did you say
But I died. Therefore, substitution. I have paid substitution. That was allowed.
Huh? By which order?
No, I am stating in my affidavit all details. My affidavit in reply filed on.
No. First point out the order by which you were substituted.
My lord. 21/4/2023. In IA number 3855/2022.
IA 21/4. 21/4.
Yes, my lord. 21/4/2023. And the IA number is 3855/2022.
This has not even been corrected. These changes have not been recorded in the pleadings.
My lord, I have filed my affidavit in opposition, my lord.
Have you seen this order? IA. Do you have a copy of that order passed in the IA?
Yes, ma'am. Yes, my lord.
This order directed the registry to make necessary corrections in the course title. That has not been carried out. Let it be carried out. You write, heard Mr. So-and-so, learned counsel for the petitioner who submits that the petitioner, namely, what is his name? Nogen Payeng, filed an IA, being IA number 3855 of 2022, and by orders of this court passed on 21/4/2023, he was substituted in place of the present petitioner who expired on 26/09/2021.
26/9/2021.
But your writ petition is filed in 16.
I have filed my writ petition on 24/11/2016.
On 26/9/2021, after filing of the writ petition. He being the son of the petitioner, he filed an application for substitution. Stop this court, coordinate bench of this court by order dated 21/4/2023, allowed the prayer, allowed the IA directing the applicant to be substituted as a petitioner, and the registry was also directed to make necessary correction in the course title. Stop. However, then you write in the writ petition, on 21/4/2023, this court permitted the respondents to obtain necessary instructions in the matter, and also directed extra copies of the writ petition to be served on Mr. R. Baur Pujari, Standing Counsel Finance, and registry was also directed to reflect the name of the Standing Counsel Finance in the course list. Stop. Para. Today, when the matter is called up and the pleadings and the court records are perused, it is seen that the direction of this court in IA number so-and-so by order dated 21/4/2023 in respect of the corrections required to be carried out by the petitioner, by the registry, has not yet been carried out. Accordingly, let the matter be brought to the notice of the Registrar Judicial for carrying out the directions contained in the order dated 21/4/2023, passed in IA number so and so. List the matter after. List the matter again in the regular Part 2 hearing list.
Regular Part 1 daily.
Part 2.
Hello, there is urgency, my lord.
You make a mention, we'll take it up. The difficulty in Part 1 hearing is it has to be listed on every date. If it is in the Part 2, it remains in the list. You make a mention, we'll take it up.
The Lordship, Mr. P. Naik's name may be recorded for SCPWD.
P. Naik appears for SCPWD. Yes. You are arguing in which matter?
Well, in the item number 8, the constitutional validity of the
Item
OM of 2023. 8, Langtha Sarades. Well, in fact, that's the base case. Once the judgment is given, the principle will apply to you.
I'm told my allotment will take whole of the day. And the earlier arrangement was he will complete his argument today, and I'll give my reply later on. So I pray my lord that for my reply next Monday may be kept. I'll give my learned friend Mr. Boro will be there.
Monday may not be possible. We don't know.
50% agree.
No problem.
We'll see.
Let him complete. In the meantime, because private respondents are also there, they also argue. They may argue today.
Mr. Chaudhary has already argued. I'm told his junior told me that he'll give a rejoinder after he is free from the vacation.
My learned friend will be there. He'll take note so that I can attend my other meetings.
Yes, certainly.
May it please, your lordship.
Yes.
My lord, just summing up my earlier arguments, my lord, our challenge to the OM of 18 January 2023 was very specific. We challenged it on the ground that the government of Assam, fully being aware of the judgment of the single judge in the Bhagwan Patta's case and the division bench's order in the IV Gohai's case, did not proceed to make promotion cadre-wise, because there is no escape from the cadre-wise promotion in terms of the law of the land. What they did, they brought an OM when the Bhagwan Patta's judgment was there.
Let us first see what was the direction of the
Yes,
court
yes,
in
yes.
IV Gogoi and Bhagwan.
First, I will, lordship, I will take to the ratio of Bhagwan Patta. Well, the operative part of the judgment of Bhagwan Patta, where the ratio is at, starts at page 103.
Who, somebody supplied this?
Yes,
cases?
my lord, these are the,
You have started.
Yes,
You have supplied.
yes, this is the compilation of the judgments which I'll be referring.
103 is
My lord, your lordship can take up item number 8 at WPC 363.
yes,
Because
that is
that
what
is
I'm
the
taking up.
challenge to the OM.
Yes, yes.
So from there, can I read? Page 103.
From the pleadings.
Yes.
Okay. Yes.
No. 103, lordship. This was the last part and the operative part. Whether clause 4 is violative of section 5 of the 78 Act
Come
and
back
therefore
and
liable to be,
send him to.
whether
Yes.
clause 4 is violative of section 5 of the 78 Act and therefore liable to be struck. The clause 4, which was the offending office memorandum, provides that in a given situation, when the percentage earmark is achieved, but some reserved category candidates who on its own merits are entitled to promotion, his or her promotion shall be considered on merit, subject to the further condition that the said person has not gained any seniority by way of accelerated promotion. Thus, from a reading of clause 4, it is clear that the consequential seniority is withdrawn for those persons belonging to SC and ST. That is my petitioner.
1 minute, 1 minute.
Yes.
In this writ petition, what was the challenge? It was
Yes.
challenge to the office memorandum.
It was a challenge of an office memorandum of 60, especially clause 4, which took our right to compete on merit, because our right to compete on merit flows from the constitutional provision.
And it is this office memorandum.
Yes,
uh,
3860.
3860.
Yes, which is at page 63.
Which has now been
Interfered-
substituted by another office member.
Yes, in fact, the honorable single judge came to a finding with reasons, if I may read it.
All right.
Thus, from a reading of clause 4, it is clear that the consequential seniority is withdrawn for those persons belonging to the SC or ST who are eligible for promotion on merit, but has got accelerated promotion. The said clause nowhere declares that the policy of consequential seniority has henceforth not been applicable to all the promotions made under section 5 of the 78 Act. That being the position, this court, can I read?
Yes.
Unhesitedly holds that the policy of providing reservation in promotion with consequential seniority being holding the field as per the OM dated 12/3/2002, the state is not within its competence and jurisdiction to deprive such service benefits to a meritorious reserve category candidates, and that too without expressly bringing out policy by superseding the benefits given under 12/3/2000.
Yes.
The aforesaid determination thus can be summarized in the following manner. The policy of the state in providing reservation in promotion with consequential seniority is discernible from section 5 of the 78 Act, read with the OM of 12/3/2002. The office memorandum dated 12/3/2002 shall hold the field till such policy is expressly repealed by the state. OM dated 3/6/16 is notified laying procedures for collection of quantifiable data on backwardness and inadequacy of representation and determining efficiency in administration while giving effect to such policy of providing reservation. Given the decree of Jarnail Singh, the OM dated 8/3/8/16 cannot sustain. So far, the same relates to the collection of data on backwardness. The determination of a cadre as a unit for collection of quantifiable data as laid down in the OM of 3/6/16 conforms to the mandate of Jarnail Singh and Nagraj, and therefore the same is upheld. The procedure as laid down for determining efficiency in administration not being arbitrary and not being based on extraneous consideration, the same is upheld. Article 16(4)(b) enables the state to carry forward the vacancies, and the vacancies carry forward. It cannot be included in the ceiling of 50% of the year of filling up vacancies. Section 5A of the 78 Act permits carry forward vacancy, and therefore the policy of carry forward as provided in the office memorandum dated 3/8/16, not being arbitrary and not being based on any extraneous consideration, is upheld. Given the dictate in Jarnail Singh, the judgment made in Equality Forum relating to collection of data on backwardness has been redundant. 16(4) article and 16(4)(b) being enabling provision, this is important, my lord. There lies the catch. The state is at liberty to implement its policy of giving reservation in promotion with consequential seniority, at liberty to provide for reservation in promotion without consequential seniority, or at liberty not to provide any reservation in promotion. However, this part was not read on the earlier occasion by the respondents. This, however, while implementing, adopting, changing such policy, due process of law need to be followed, including the dicta in Nagraj clarified in Jarnail. The impugned office memorandum is interfered to the extent the two petitions are allowed in the aforesaid terms and are disposed of. My lord, my submission is that the Supreme Court's judgment of R.K. Sabharwal was being upheld by the learned single judge in clear and categorical terms to mean that the benefit which we get on merit as we go up, you cannot stop it on the ground that the earlier promotion we got it by accelerated and promotion. Because if you touch it, virtually you will be touching on a constitutional provision, because at no point of time our seniority and our accelerated promotion was interfered. Now, by an OM of 16, you are trying to take away our part and give us the benefit under the 78 Act. You split up the 1978 Act into two parts. We will give you accelerated promotion, no problem. That's the policy of the government in paragraph 1 of all the OMs. But they add a rider that if you got earlier promotion, you will be debarred on merit. Which is, what is the law? This is not a law in this country. The law has been flowing from Nagraj and Jarnail is that once we are given the accelerated promotion, it is not an additional benefit, because we get normal cadre promotions. And when we go up a cadre, the rules are very specific. I'll come to the rules. The rules are very specific. Even the gradation list has to be made in terms of cadre. As a result, we get our cadre and we go up the ladder. Today, by a stroke of a pen, you brought this OM. When this OM was quashed, the Assam government did not implement that order and waited. And in the January of 2023, they brought up a new OM, which is at page 107, the new OM of 18 January. In fact, your lordship, I will show that the new OM of 2023 is basically the same OM of 16. They rephrase it, make it more unconstitutional, and they try to override the statutory powers given, rights given to us. The lordship will come to page 107.
Now, after the single bench judgment, what happened?
Yes.
Was there an appeal?
After the single judgment, the division, the Assam government did not go on appeal. These respondents, the general, they went on appeal. They filed an appeal, and that was answered in IV Gohai's case. And the IV Gohai's case added something more.
Where is that?
Yes.
My lord, I'll not interrupt my learned friend, but this OM which they have challenged here, I'm not interrupting him. Is in the background of certain facts. Those facts should be placed properly so that this court understands in what context and under what background the present OM has been. Abruptly reading from a judgment, my lord, I don't know. For me, it becomes very difficult. What is the points he is trying to argue? Because there is a background starting from that first one-man committee report.
We will hear it from you.
My lord.
Malan, in fact,
Get
from
it
the
from-
background, from documents now I'll be showing, the Assam government has misled the Honorable Guwahati High Court on 2 occasions before the division bench and seeing that documents I have. I'll show it.
Misled
And
is a very
this
strong
is a
word.
serious case, Mala. The
Very
chief
strong
secretary,
word.
who is supposed to be the head of the bureaucracy, he misleads this honorable court by giving 2 documents at 2 different points of time, which has a bearing in this case. I'll come to this.
All right.
In my
Now-
second
Now
part.
let's go back to the appeal.
Yes, then I'll come to my OM, Lordship.
No. First, let us find out what happened
Yes.
after the single
Yes.
bench.
Malad, in the IV Gohai judgment, the operative part, the arguments which was advanced, 13. Malad, was basically both by the state and the respondent, the state never filed any appeal, was that
No,
with
but where does one get the judgment?
Malad, on the last occasion, the compilation was.
Oh, yes, Writ Appeal 46. Yes, okay. Yes.
Malad, there, the arguments was only one, that the arguments of the respondents, both state and the private respondent, was that the 2016 OM, with the coming of the 2016 OM, which brought in the clause 4, the OM of 2002, which gave us the benefit of consequential seniority pursuant to the 85th Amendment, was withdrawn. To this, the Honorable Single Judge, Division Bench, gives a finding at para 37 of IV
Let
Gohai.
us go through the judgment carefully.
Yes.
Because this is a division bench judgment.
Yes.
We want to find out if the division bench has laid down or said or
Yes.
observed anything.
Yes.
Which may be construed to be binding on this bench while hearing this matter. That's the only purpose.
Yes.
Right. So maybe you can start from para 2 onwards.
No, I'll go to Kamath.
Yes. If I may read para 2. The facts and circumstances leading to the present appeal flows from Constitutional 77 Amendment introducing 16(4)(a), by which it was provided that nothing shall prevent the state from making any provision for reservation in the matters of promotion to any class or classes of post in the service under the state in favor of SC/ST, which in the opinion of the states are not adequately represented in service under the state, and the Constitution 85th Amendment, wherein an amendment was brought to the 16(4)(a), providing for reservation in promotion with consequential seniority. The Constitutional 77 Amendment to the Constitution, as per the Constitution 77 Amendment 95 and the 85th Amendment 2001, it has to be taken note that in the state of Assam, by the Assam Act of 79, the Assam Scheduled Caste and Scheduled Tribe Reservation of Vacancies in Services and Post 78, as per Section 5 thereof, reservation of Scheduled Caste and Scheduled Tribe in the post to be filled up was already statutorily provided for. After the 77 and the 85th Amendment to the Constitution, the government of Assam through the Department of Personnel issued an office memorandum under the signature of the Commissioner and Secretary to the Government of Assam in the Personnel Department, dated 12/3/2002, providing for consequential seniority to the SC and ST servants on their promotion by virtue of the rule of reservation, and the office memorandum clearly provides that such provisions was consequent upon the amendment of 16(4) of the Constitution of India, 85th Amendment. In other words, it has to be understood that by virtue of Section 5 of the 78 Act, the provisions for reservation and promotion to a reserved category was already introduced in the state of Assam prior to 77 Amendment of the Constitution, whereas by the OM of 12/3/2002, even the consequential seniority upon such reservation on or promotion being acted upon was also provided pursuant to the 85th Amendment. It is also to be taken note that the Assam Act of 2012, notified by the notification of 21/8/12 and published in the Assam Gazette of 21/8/12, Section 5A was introduced after Section 5 of the Act. The 5A of the Act of 78 provides for post-based roster for implementing reservation in promotion for the members of the reserved class. After the amendment of 78 Act by the Assam Act, the office memorandum dated 29/12/14 was issued under the signature of the Principal Secretary, WPT. The opening paragraph of the office memorandum dated 29/12/2014 provides the guidelines where, in order to implement the post-based roster reservation in the matters of promotion for the post of SC and SC, both plains and hills, in direct recruitment and promotion. Considering the nature of arguments raised, it would be relevant to take note of the provision of Section 1.11 of the office memorandum dated 29/12/14, as well as Clause 14, which are extracted below. The rosters are an aid to determining the entitlement of different categories with regard to their quota reserved for them in matters of appointment and promotion. They are not intended to determine seniority in the cadre. All existing orders on the subject are deemed to have been amended to the extent herein. WPC 150 and such WPC was instituted by the registered society in the name of Equality Forum, and 4 other persons serving as assistant engineer in the irrigation department and seeking promotion to the next cadre of assistant engineer, executive engineer. In both the writ petition, an issue was raised that as per the judgment rendered by the Honorable Supreme Court in Nagraj and in UP Power Corporation, there is a requirement of the state to have a quantifiable data on the backwardness and inadequacy of representation of the reserved category for the purpose of promotion. According to the petitioners in the said 2 writ petition in the state of Assam, no process was initiated for obtaining the data as regarded in Nagraj and UP Power Corporation. Apart from the report of the one-man committee constituting H. Sonwal, the then commissioner to the WPT, which report was also inadequate and unacceptable, and as such, further continuation with the provision of reservation as well as providing will be unsustainable with law. In the said 2 writ petition referred to Equality Forum, in paragraph 47, it was provided that till the exercise of data relating to 3 constitutional requirements of backwardness, inadequacy, and overall efficiency in the event of reservation, as mandated in Nagraj and UP Power Corporation is done, and an opinion is formed by the state based upon the quantifiable data so collected as to whether the enabling provision of 16(4)A is to be invoked. Reservation in promotion would remain in a dormant state. The para 47 of the Equality Forum is extracted in a separate proceeding related to reservation and promotion in the irrigation department. This court held that there is no quantifiable data before the court regarding the 3 constitutional requirements, namely backwardness of the class, inadequacy, and overall efficiency in the event of reservation in promotion. It was held that in the absence of
This is a single bench judgment.
Yes.
Equality Forum.
Yes. And single bench, yes.
Okay.
Can I read?
Yes, yes.
In paragraph 67 of judgment in Equality Forum, it was provided that the quantifiable data has to be both service and cadre specific. And from that time onwards, it was cadre specific. And that the one-man commission appointed by the government of Assam to collect the data has done was that it had made a general statement of backwardness of the SC/ST and has not provided data either on backwardness or inadequacy. It was further provided that if, upon undertaking the exercise of data, it was found that in a particular cadre there is adequate representation of the SC and the ST, providing for reservation in promotion to such cadre would not be justified. In paragraph 68, it was provided that in the event of reservation is sought to be introduced, even an assessment of backwardness of the committee regarding their representation in the promoted cadre would have to be carried out. In paragraph 74 of the judgment in Equality Forum, it was provided that though the state has made provisions for reservation in promotion by enacting the 78 Act, which was amended in the year 12, implementation would depend on acquiring of data, which exercise has to be cadre-wise in the context of the service where the cadre is praised. Accordingly, it was provided reservation would has to be justified with the help of quantifiable data to show the presence of two compelling reasons, backwardness and inadequacy, which has to be harmonized with the efficiency in administration. Malad, this paragraph 74 basically talked about that three conditions was required. One is backwardness, inadequacy, and efficiency. But subsequently, the Jarnail Singh case said that this backwardness was not required because they are already backward under the presidential notification of 1950. So this data is not required. So what was now required is the inadequacy of representation in the cadre and the efficiency. But later on, the efficiency part was also removed in the Pavitra's case. Malad, this is the same observation which I have said. Malad, then I will come to the OM of 16. Which is at page 15, paragraph 11, which was the offending which I read, Lordship. Paragraph 4.
Yes.
Paragraph 4, will I read again?
Para?
Para 4 at page 16, Roman 4. That was the offending. Well, basically, the Assam government took away the benefit of merit because they put a rider, we will give you, provided you did not get your accelerated promotion earlier. Then at para 12, can I read?
Yes.
The respondent won in writ namely Bhagwan Patar instituted civil assailing clause 3 and 4 of the office memorandum of 16 on the ground that it would have been an effect of de-reservation in respect of promotion, and secondly, promotion on the basis of merit which is otherwise due to the reserve would be taken away. The Society Equality Forum, which had earlier instituted the writ petition resulting in the judgment in Equality Forum.
So 3 was for de-reservation.
Yes, 3 was de-reservation because our case was.
In case of not.
Yeah, because after the post-based reservation, it is now cadre is fixed. So how can you de-reserve? Because the replacement theory comes, I go as a STP, once I'm up, my below STP in the feeder gather, that officer comes and takes my position. So there is no shortfall or no excess. Because R.K. Sabharwal wanted to finish this problem of excessive reservation discrimination, reverse discrimination, which the general were all along making their case both in Ajit Singh and in Virpal Singh Chauhan. Those were the position prior to the 85th Amendment. And this was completely this Parliament in India took that if we go by those judgments and bring in the catch-up principle, ultimately never will the SC and ST take position in the higher ranks of service. Because the main purpose of reservation, it was a mode of achieving equality, and you cannot deprive that class. So the Equality Forum's, the Bhagwan Patar's judgment challenged that part that how could you deprive us merit when the merit we get it in terms of the OM of 2014. Malad, a very incongruous situation is now arising in Assam. In 2014, which I'll take your lordship, there's a specific provision which gives that when we go up the ladder, merit will be given to us at every level. That 2014 was completely bypassed, erased, and the 2016 comes in. That is the ballast. Well, how can, when a provision is there in the rules in your own OM and the Supreme Court judgment, you bring in a 16 OM to deny us? And the entire argument of Bhagwan Patar was, and IV Guha was, their case was simple, that the 2002 OM has been now deleted by the 2016 OM. My argument was 2016 OM has nothing to do with 2002 because 2016 OM is basically reviewing the policy of giving quantifiable data and inadequacy of representation and efficiency, which has been answered by IV Guha. But you, the 2014 OM, you ignore it by bringing in clause 4. That was my case. And that was accepted both by the single judge and the division bench. And the argument of my learned friend, Mr. K. Chaudhary, was rejected on similar grounds in both the forums. So that submission of my learned friend on the earlier occasion does not stand a chance. It does not have legal force because that has been conclusively decided in two judgments, both by the single bench and the division bench. And in fact, your lordship will find at para 39, the honorable division bench sums up.
No, you'll have to take us to the other.
Yes, I'll take up
Yes.
to that. Only for your understanding. Then page 70. Then your lordship will come to para 30. The two writ petitions being 505 and 5026 was decided by the single bench by judgment dated 6/6/22. That is the Bhagwat Bhattacharya. Without going into the arguments and counter arguments that were raised by the parties in the aforesaid two petition, we take note of the determination that has been made by the learned single judge at paragraph 7 of the said judgment dated 6/6/2002, which are extracted below. Can I read?
Yes, please.
The policy of the state in providing reservation in promotion with consequential seniority is discernible from section 5 of the Act of 78, read with the OM of 12/3/2002. The office memorandum dated 12/3/2002 shall hold the field till such policy is expressly repealed by the state. The OM dated 3/6/16 is notified laying procedures for collection of quantifiable data on backwardness and inadequacy of representation and determining efficiency in administration while giving effect to such policy of providing reservation. Paragraph 5, in paragraph D3 of the said judgment, it has been further held as that being the position, this court unhesitedly holds that the policy of providing reservation in promotion with consequential seniority being holding the field as per the OM dated 12/3/2002, the state is not within its competence and jurisdiction to deprive such service benefits to a meritorious reserve category candidates, and that too without expressly bringing out any policy by superseding the benefits given to under 12/3/2002.
Yes.
From the judgment and order dated 6/6/2002 of the single judge, it is discernible that in respect of the challenge to clause 4 of the OM of 16, it has been provided that the policy of reservation in promotion with consequential seniority has been holding the field as per the office memorandum dated 12/3/2002. The state is not within its competence and jurisdiction to deprive such benefit to a meritorious reserve candidate, and that too without expressly bringing such policy by superseding the benefit given in the OM of 12/3/2002. With regard to the challenge of the Society Equality Forum as regards the entire office memorandum of 3/8/16, it has been provided in the order dated 6/6/2 of the learned single judge in paragraph 7/8 that having given the dictum of Honorable Supreme Court in Jarnail Singh, the judgment dated 23/12/15 rendered in Equality Forum has been become redundant. In other words, by the judgment dated 6/6/22 in WPC, the learned single judge firstly held that the clause 4 has to be interpreted in a manner that the policy of reservation with consequential seniority benefit has been.
Mr. Das will come back at 2.
Yes, yes.
My lord, I have two similar matters in this series, my lord. It was heard by Honorable CJ, my lord, and during December it was released. So what I pray before your lordship that that two matters may be heard. This is not with the series, my lord.
You want your matters to be connected to the series.
I'm also there.
It is a pertaining to reservation, my lord.
You mentioned these matters.
My lord. I'll give the numbers, my lord.
Tomorrow you mention these matters, we'll pass
Well,
orders on that.
I'll do that.
Yes.
All right, sir.
Lordship, paragraph 16. Can I start? From the judgment and order dated 6/6/2022 of the learned single judge, it is discernible that in respect of the challenge to clause 4 of the office memorandum of 21/16, it has been provided that a policy of providing reservation in promotion with consequential seniority having been holding the field as per the office memorandum dated 12/3/2002, the state is not within its competence and jurisdiction to deprive such benefit to a meritorious reserve candidate, and that too without expressly bringing such policy by superseding the benefits granted under office memorandum dated 12/3/2002. With regard to the challenge of the Society Equality Forum, as regards the entire office memorandum dated 3/8/16, it has been provided that in the order dated 6/6/2002 of the learned single judge in paragraph 7(7), that given the dictum of the Honorable Supreme Court in Journal Singh.
What is a meritorious reserve category?
Meritorious is, it's talking about the merit, means when we compete at the higher cadre, we compete on merit because our ACRs are taken into consideration along with the general. So we leave our reserve thing and we compete as a member of the unreserved, and that is the law starting from R.K. Sabharwal till Indra Swani, that when we compete, we go as a member of the unreserved. In Assam, they wanted to take that out. Basically, Assam government wanted to form a quota for the general on merit, which is not permissible. That was our entire case was on that.
Yes.
It has been, the judgment dated 23/12/15 rendered in Equality Forum has become redundant. In other words, by the judgment dated 6/6/2022 in 505, that is Bhagwan Patar, the learned single judge firstly held that the clause 4 of the office memorandum has to be interpreted in a manner that the policy of reservation and promotion with consequential seniority benefit having been provided by the office memorandum dated 12/3/2002, it is beyond the competence of the state to deny service benefit to a meritorious reserve candidate. That was our case, without superseding the office memorandum dated 12/3/2002, and with regard to the claim of the Equality Forum, that although in paragraph 47 of the judgment in Equality Forum, it has been provided that till the quantifiable data is collected, the policy of reservation shall remain dormant, but the requirement of giving the policy dormant shall not hold good in view of the subsequent judgment of the Honorable Supreme Court in journals. In fact, Lordship, I'll just like to add one thing for your Lordship's consideration, that the OM of 2002 came pursuant to the 85th, and there is an argument on the other side saying that the state can, it's an enabling provision. I do understand it's an enabling provision, but when the state of Assam having itself issued the OM of 2002 has enabled itself to give the benefits. Then in paragraph 17, Ivy Gohans Dasgupta, who is an unreserved category candidate and is a respondent in WPC such, has instituted such seeking leave to appeal against the judgment and order dated 6/6/2002 in such on the ground that the conclusion arrived herein had adversely affected the legal rights of the said applicant. Along with their interlocutory application, a memo of writ appeal was also presented before the registry, which was not numbered at the stage, was given its consideration by order dated 31/12/2023, granting leave to Dasgupta to prefer an appeal against the judgment and order dated such. In the circumstances, writ appeal such has been registered. Some of the unreserved candidates category has instituted writ appeal also being agreed by the judgment and order dated such. Paragraph 18. The Society Equality Forum, who were the writ petitioners in such, has instituted writ appeal on their own grounds, being aggrieved by the conclusion of the learned single judge as regards their plea that in spite of the judgment in Equality Forum in paragraph 47, reservation in promotion has not been kept in dormant state. And by the office memorandum of 16, reservation in promotion was allowed to the same manner without collecting of data. Mr. Chaudhary, appearing for the appellant and other appellants, have raised the contention, this is their argument, that by the office memorandum dated 29/12/14, the consequential seniority meted to the reserve by the earlier OM of 12/3/2002 has been superseded, meaning thereby that the provision of the consequential seniority pursuant to the enabling provision of the Constitution 85th Amendment has been withdrawn, Accordingly, Chaudhary assails the conclusion of the learned single judge in the judgment and order dated such. As regards clause 4 of the office memorandum dated 3/8/16, it is the submission of Mr. Chaudhary, learned senior counsel, that in consequential seniority itself has been withdrawn by the state authority. No further question remains on any claim of the reserved category candidates for consideration on merit pursuant to the consequential seniority. Mr. Chaudhary substantiates his contention by referring to clause 1.1 and 14 of the office memorandum dated 29/12/14, that a conjoint reading of the provision of the two clauses would make it apparent that the earlier provision of consequential seniority meted by the office memorandum dated 12/3/2002 has been withdrawn. It is also the submission of Mr. Ken Chaudhary, learned senior counsel, that consequential seniority in pursuant to an enabling provision under 16(4) as introduced by the 85th Amendment, and therefore is being an enabling provision, it always remains the discretion of the state authorities to withdraw the consequential seniority as per their requirement. Mr. Das, learned counsel for Bhagwan Pata per contra, contends that 1.1 and 14 of the office memorandum dated 29/12/14, even on a conjoined reading, does not indicate in any manner that a consequential seniority meted by the earlier office memorandum dated 12/3/2002 has been withdrawn. Mr. M.K. Chaudhary, senior counsel for the Appellate Equality Forum, on the other hand, has raised the contention that the provision of paragraph 47 of the judgment in Equality Forum was explicit enough to provide that till such time the quantifiable data on the elements of backwardness and inadequacy of representation, coupled with a harmonization of the administrative efficiency under 335 is obtained, the provision for reservation and promotion would remain dormant, and therefore, as no collection of any quantifiable data has been put on record, the embargo provided by paragraph 47 of the judgment in Equality Forum prevails, and no such benefit of reservation and promotion can be given to any reserved candidate, let alone any consequential senior. Mr. Das, learned counsel for the respondent who represented all the reserved category, per contra, raises the contention that in Journal Singh in paragraph 32 and 36, the Supreme Court's having provided the provision that the provision in Nagraj providing that the state has to collect quantifiable data showing backwardness of the SC/ST being contrary to the 9-member bench in Indira Sawhney to be invalid to such extent that as there is a presumption of backwardness in favor of the SC/ST, therefore there may not be any further requirement to obtain any data to substantiate their backwardness. The relevant portion of 32 and 36 is extracted. It has been seen that the bill containing two things that are different from Article 16(4) has already enacted. First and foremost, it clarifies that the SC and the SC/ST that are not notified under 341 and 342 shall deem to be backward, which makes it clear that no data is necessary to determine backwardness. Thus, we conclude that the judgment in Nagraj does not need to be referred to any 7 judges bench. However, the conclusion in Nagraj that the state has to collect quantifiable data showing backwardness of the SC/ST being contrary to the 9-member bench of Indira Sawhney is held to be invalid to that extent. In fact, that's the reason the Equality Forum was.
That was in Journal.
Yes, Journal. And that was the reason why it was held that the Equality Forum judgment has become redundant, because Equality Forum never talked about this. Thus, learned counsel also refers to the judgment in the Supreme Court rendered in Nagraj, wherein in paragraph 47, it has been provided that collection of data as regards inadequacy of representation of the reserved category would have to be done cadre-wise. This is my submission, and submitted that as the collection of data as regard inadequacy would have to be determined cadre-wise, therefore there cannot be any centralized procedure set in place for collection of data regarding inadequacy of representation, and as such, inadequacy would have to be determined cadre-wise and case-wise in respect of every such promotion under consideration of any given cadre. That is my argument, that as I go up my cadre, I will be getting my seniority also. It is further contended by Das that the Honorable Supreme Court in V.K. Vavitra versus others in paragraph 126 has held that the framers of the Constitution did not define what is meant by efficiency of administration, and that 335 cannot be construed on the basis of a typical assumption that roster point promoted drawn from SC and ST are not efficient or that efficiency is reduced by appointing them. It is also provided in paragraph 116 of the said judgment that no citizen can be discriminated on grounds of race or religion. In fact, here I'll stop, Lordship, pause. This argument that efficiency has to be measured, and in fact, an argument was advanced by my learned friend, Mr. Chaudhary, that we get all our promotion by subterfuge. Well, the meaning of subterfuge is deceit. He cannot use the word for the simple reason when we go up the ladder, we get it by selection through an open selection where the general also compete. Now to shut us from that itself is unconstitutional. That is the main area. In fact, I'll show from my cases, my clients who were on top of the list all brought down and their seniority retrospectively taken back. In fact, one of the members of the civil service, he was on number 1, Mr. Prabir Kakoti. He goes to 24 for no fault of his. Paragraph 116 and 126 of the BK Pavitra has extracted below. By recognizing that formal equality of opportunity will be insufficient in fulfilling the transformative goal of the Constitution, these members recognize that the concept of equality of opportunity must recognize and account for existing societal inequalities. The most revealing debate as to how the Constituent Assembly understood equality of opportunity under the Constitution took place on 30/11/48. Members debated draft 10, which would go on to become Article 16 of the Constitution. In these debates, some members understood subclause 4 providing for reservation as an exception to the general rule of formal equality enunciated in subclause 1. Illustratively, an articulation of the position was made by Muhammad Ismail Khan, who stated, there can be only one of these two things, either there can be clear equal opportunity or special consideration. Article 10 says there shall be equality of opportunity. Then it is emphasized the fact by a negative clause that no citizen can be discriminated on grounds of religion or race. It is quite good, but when no indication is given whereby this would override 296 or 296 is independent of which are certainly left in the lurch, what would be the fate of the minorities? Article 296 stated that special consideration should be given to minorities to ensure representation in service. The Constitution does not define what the framers made by the phrase efficiency in service, of efficiency of administration. Article 335 cannot be construed on the basis of a stereotypical assumption that roster point promotees drawn from SC and ST are not efficient, or that efficiency is reduced by appointing them. This is a stereotypical because it masks deep-rooted social prejudice. The benchmark for efficiency of administration is not some disembodied abstract ideal measured by the performance of a qualified open category candidates. Efficiency of administration in the affairs of the state or union must be defined as an inclusive sense where diverse sections of the society finds representation as a true aspiration of governance by and for the purpose. If, as we hold, the Constitution mandates realization of substantive equality in the engagement of the fundamental rights with the directive principles, inclusion together with the recognition of plurality and diversity in the nation constitute a valid constitutional basis for defining efficiency. Our benchmark will define our outcome. If this benchmark of efficiency is grounded in exclusion, it would produce a pattern of governance which is skewed against the marginalized. If this benchmark of efficiency is grounded in equal access, our outcome will reflect the commitment of the Constitution to produce a just social order. Otherwise, our past will haunt the inability of our society to move away from deeply unequal to one which is founded on liberty and fraternity. Hence, while interpreting 3335, it is necessary to liberate the concept of efficiency from a one-sided approach which ignores the need for and positive effect of the inclusion of the diverse section of the society on the efficiency of the administration of the center or the state, establishing the position of the SC and ST as worthy participants in affairs of governance is intrinsic to an equal citizenship. Equal citizenship recognizes governance which is inclusive but also ensures that those segments of our society which have suffered a history of prejudice discrimination, and oppression have a real voice in governance. Since inclusion is inseparable from a well-governed society, there is, in our view, no antithesis between maintaining the efficiency of administration and considering the claims of the SC and ST to appointments to service and posts in consonance with the affairs of the union or the state. Accordingly, it is the contention of Sri D.K. Das, Learned Counsel for the Reserve, that the Honorable Supreme Court of India has done away with the requirement of quantifiable data regarding backwardness, and also having held that the collection of quantifiable data regarding inadequacy in administration cannot be on a stereotypical assumption that reserve candidates are otherwise inefficient. What further remains is the data in respect of adequacy or inadequacy of the reserve. But again, the collection of data in respect of adequacy or inadequacy of representation has to be circumscribed by the Supreme Court in journal, and therefore such collection of data would have to be understood as part of circumscribed requirements as provided by the Supreme Court. As the circumscribed requirement is to collect data cadre-wise and service-wise, therefore it would be more prudent if instead of undertaking an exercise to obtain quantifiable in a comprehensive manner applicable for the whole of the state, of all such cadres and services that are in place, the same purpose can be achieved. If the Department Promotion Committee, while considering any promotion to the respective cadre before proceeding with the promotion, obtains the data regarding adequacy or inadequacy of representation of reserve in respect of such promoted cadre for which the promotion process will be undertaken. With regard to the contention raised by Chaudhary, Learned Counsel for IV Gohai and the other applicants, that the provision of the consequential seniority having been provided by the 85th Amendment, which itself is an enabling provision, it is always the discretion of the state authorities who provide for such consequential seniority to, or also withdraw the said provision of consequential seniority to. It is taken note that an enabling provision in the statutes is understood to be a provision which does not provide for any specific provision, but a statutory provision enables the executive to provide for such provision if otherwise advised or justified under the law, meaning thereby that it's a discretion vested on the government through delegation to either provide or not provide. The only compelling circumstances that remain would be that once in exercise of enabling provision, if a particular provision is provided, till such provision remains in force, it will be binding for all as regards the requirement to implement such provision. But at the same time, in the same manner in which a discretion was vested in the executive to provide for such promotion, if so advised and justified under the law, equally it would also be open for the state to withdraw such as per their own discretion, again subject to if justified in the circumstances as well as under the law. In fact, here I'll add, Palat, is single judge has said you can do, you may not do, but it has to be journal and Nagras compliant. From such point of view, we are in agreement with Chaudhary Learned Counsel that the office memorandum of 14 could also withdraw, could have also withdrawn the benefit of consequential seniority meted to the reserve candidate by the earlier office memorandum of 2. But at the same time, although the enabling provision enables the state to withdraw such benefit, but that would further have to be examined as to whether the office memorandum of 29/12/14 in fact withdraws the benefit meted to the office. To substantiate the contention that the office memorandum dated 29/12/14 has in fact withdrawn the consequential seniority given earlier by the office of 12/3/2002, Mr. Chaudhary Learned Counsel relies upon 1.1 and 14 of the memorandum dated 29/12/14. A reading of 1.1 of the office memorandum dated 29/14 makes it discernible that the rosters are in aid to determine entitlements of different candidates with regard to the quota reserved for them, but they are not entitled to determine the seniority. In other words, we are required to interpret the meaning of the word "they" appearing in clause 1.1. The expression "they" referred to the earlier sentence in 1.1 that the roster are in aid to determine the entitlement of different categories. In other words, the expression "they" refers to the roster. The first paragraph of the office memorandum dated 29/12/14 provides that the office memorandum has been issued consequent upon the amendment to the Act of 78 and the acceptance of the recommendation of the one-man commission constituted by the state of Assam. We have taken note that the recommendation of the one-man committee referred in the office memorandum 29/12/14 had in meantime been held to be unacceptable as per the judgment of the court in equality forum. At this stage, we take note that in fact there are two judgments available both in respect of petitioner instituted by Society Equality Forum. One such is the judgment dated 23/12/15 rendered in such, reported in such, and the other is the judgment dated 6/6/1 in such. For clarity and convenience, we refer the judgment referred in Equality Forum reported in 16 to be 1 and a judgment of 6/6/22, that is Bhagwan Patar, to be 2. Equality Forum 2. In other words, the purport of the office memorandum dated 29/12/14 has to be understood that it was issued consequent upon the amendment to the 78 Act. As noted above, by the 12th Amendment, the Act of 78 has been amended by which Section 5A has been introduced. It has also taken note thereafter that 5A of the 78 Act provides for post-based reservation for implementing reservation in promotion. As the office memorandum dated 29/12/14 has been issued consequent upon the amendment by which 5A of the Act of 78 has been introduced, the word roster in 1.1 and the further provision that the roster do not intend to determine seniority would have to be understood in the context of 58, 5A. All that 5A of the Act of 78 provides is that earlier the reservation in promotion was given effect by following the procedure of vacancy, but on the introduction of 5A, the same would be done by roster in the roster scale. If a reservation in promotion is given effect on implementation based upon roster point in the roster, there is always a possibility that a roster category, this is important, that a roster category candidate may be promoted against the post, which may be a little higher up in the roster scale, as the said roster point may have fallen vacant. In that circumstances, the provision of clause 1.1 would have to be understood that the seniority referred therein related to the roster would mean that if a reserve candidate is promoted against a roster post, which would be a little higher in the roster scale in comparison to the other promotees, who may be a little lower in the roster scale, the same will not entail any seniority over others who were also promoted in the same process, but placed perhaps a little lower in the roster scale.
Can you come again with 35? From 35, beginning,
Yes.
is the reservation?
If a reservation in promotion is given effect to or implemented based upon the roster point in the roster scale, there is always a possibility that a reserve category candidate may be promoted against the post, which may be little higher up in the roster scale, as the said roster point post may be have fallen vacant. In that circumstances, the provision of clause 1.1 or 1.11 would have to be understood that the seniority referred therein related to roster would mean that if a reserve category candidate in a promoted against a roster post, which would be a little higher in the roster scale in comparison to other promotees who may be a little lower in the roster scale. The same will not entail any seniority over the others, comma, who were also promoted in the same process, but placed a little lower in the roster scale. In other words, placement of a reserve candidate in a given roster, irrespective of the position, would not determine the seniority of such candidate, and the seniority would be determined otherwise under the law, dependent on the manner and circumstances in which the promotion was given. Here I say it is the rules. The rules fill up the gap. The rules are very specific. The rules envisage only cadre-wise promotion and seniority.
Para 33 onwards,
Yes.
the submissions or the findings of the.
No, my lord, he is coming to the finding now. Para 36 onwards, he is coming to the, because he comes to a finding on my submission and Mr. Chaudhary's submission in paragraph 37. So I'll have to read paragraph 36 to come to 37. Can I read?
No, so certainly.
This being the meaning of the provision of 1.1,
Yes.
it must be understood that clause 1.1 1.11 of the office memorandum dated 29/12/14 does not relate to any consequential seniority. This is very important. Of a reserve candidate in the context, this is the ratio. In the context of the meaning attributed to 1.1 in the manner indicated above, when we read the provision of clause 14 of the office memorandum dated 29/12/14, it is noticed that the said clause provides that all existing orders on the subjects are deemed to have been amended to the extent as provided in the said office memorandum. The expression are deemed to have been amended to the extent herein would mean that it also includes the extent as provided in clause 1.11, meaning thereby that the aspect of determination of seniority provided therein is not related to any consequential seniority, but it relates to a provision that by following a roster point system, if a reserve category is promoted in a post which is otherwise a little higher in the roster scale, it being positioned in the higher in the roster scale will not determine the seniority of the person over others who may be promoted against a post in the roster which may be a little lower. Accordingly, this is the finding, it would have to be concluded that a conjoined reading of clause 1.11 and 14 of the office memorandum dated 29/12/14 would mean that a consequential seniority that has otherwise meted by the office memorandum of 12/3/2002 has not been withdrawn. So it is the second finding of the division bench after that the consequential seniority is a must because it flows from section 5 of the 78 Act amended by the 5A of the 2012 Act. So you cannot take it. You cannot. Assam government, what they did, they broke it into two parts, which is unheard. They said, we will give you only promotion, but we will not give you consequential seniority and will prevent you from taking the benefit of merit. My lord, how can they do it? Basically, you are debarring us from our rights to compete. And in fact, their argument was always hinging that the 14 OM has diluted 2002. My lord, I'll show from the arguments which I'll now place that the Assam government, through subterfuge, what they did in the OM, in the latest OM of 2023, they know that they cannot withdraw the 2002 OM because there are two judgments of this court. One is single judge and division. To get over it, what they do, they say that this OM of 2023, which we are now bringing, will now override the 2002. It will be in supersession of 2000. At most, they can say it will be in supersession of the 2016. They cannot say that it will be in supersession of 2002 because by that process, you have abrogated our constitutional right. My lord, I'll place a judgment of the Supreme Court later on that much arguments, because we have been there for a long time from 16, the respondent council and the state of Assam has one argument all that it's an enabling provision, we will give you or we may not give you. Malo, it's an enabling provision, I do understand. But this enabling provision is now an enforceable right pursuant to the 85th Amendment by which the 2002 OM is there. And the Supreme Court has said if it is an enforceable right, you can plead it and you can challenge it in a court of law if your rights are violated. In fact, mandamus can be issued. In fact, my learned friend, Mr. Chaudhary has referred to a judgment of Mukesh Kumar. Mukesh Kumar is not on the facts of the case. Mukesh Kumar was a case from Uttaranchal where the government took a policy decision not to give promotion. Supreme Court says we will not issue mandamus. Rightly so. You give it, but in Assam, the policy of reservation is there, 78 Act is there, Section 5 is there, but you take away one part and you deny us the benefit of merit. So my argument at paragraph 37 was accepted. 38. With regard to the contention of M.K. Chaudhary, Learned Counsel for the petitioner and writ appeal, we take note that as per paragraph 47 of the judgment in Equality Forum, there is an exceptional provision by a judicial pronouncement that till such quantifiable data of backwardness, inadequacy of representation and efficiency in administration is collected, no reservation in promotion in favor of the reserve can be made further carried forward. but paragraph 74 of the order dated 23/12/15 in Equality Forum 1 provides for collection of data in respect of backwardness of the reserve as well as inadequacy of their representation, which again would have to be determined cadre-wise and service-wise in the respective department. And further, upon such data being obtained, there would be a requirement of harmonization with efficiency in administration as provided under 335. But the requirement of the provision in judgment dated 23/12/15 in Equality Forum would again have to be read in the context of the submission of D.K. Das, Learned Counsel for the Unreserved, that in paragraph 36 of the journal, there is a presumption in favor of backwardness of the reserve. And in view of such presumption, there is no further requirement of obtaining any data to substantiate. The said provision being rendered by a constitution bench judgment of the Supreme Court, when read together with the provision of the equality in Equality Forum 1, it has to be understood that there would be no further requirements under the law or for any collection of quantifiable data to substantiate the backwardness of the reserve, inasmuch as there is a presumption in law as regards the existence of backwardness. Further, we also have to take note that in paragraph 47 of the judgment of the Honorable Supreme Court in journal, it has been provided that the adequacy or inadequacy of representation of the reserve category would have to be determined cadre-wise, service-wise, and in the given relevant department. The said provision is also consistent with the provision in paragraph 74 of Equality Forum 1 that a collection of data regarding adequacy and inadequacy of representation would have to be determined cadre-wise, service-wise, and departments. If the determination of quantifiable data is for inadequacy or adequacy of the reserve candidates in a given cadre or a service in a particular department of the government, we are in agreement with the contention raised by Sri D.K. Das, Learned Counsel for the respondent Bhagavan Patar, that it would be more prudent and appropriate to undertake such exercise to the DPC itself before embarking upon a promotion process for a given cadre. The same would be prudent inasmuch as DPC will also have all the data before it as to the cadre strength of the promoted cadre, where promotion is to be considered, and out of the total cadre strength, how many posts in the cadre are to be earmarked in the reserve, and out of the earmarked candidates reserve posts, how many posts are to be occupied by the reserve category. In other words, if the reserve category candidates are occupying all the posts earmarked for the reserve category candidates in a given cadre, it can be easily understood that in the given cadre, there is an inadequacy of the representation of the reserve class. And in the event the number of reserve class in the cadre is less than the number of posts earmarked for the reserve, it has to be understood that there is an inadequacy of representation in that cadre. If the determination would be made in the above manner, we are of the view that it would be more appropriate and apposite for the DPC to take such determination, but such determination would have to be made before initiating the promotion process. In fact, in the OM, the Lordship will find that the departmental committees are given power that they will ask for the number of posts in the cadre from the government. 41. As regards the third requirement of obtaining data and harmonizing with efficiency, we take note of the provision of the judgment in Pavitra, when in paragraph 126, it has been provided that inefficiency in administration referred to 335 would be construed on a basis of a stereotypical assumption that roster point promotees drawn from SC/ST are not efficient or their efficiency is reduced by appointing them. And secondly, the provision in paragraph 116 of the judgment, wherein by referring to the constituent amendment debates in respect of the provision by Muhammad Ismail Khan, no citizen should be discriminated on account of religion, race, thereby that an interpretation is sought to be given that if across the board the reserve category candidates are construed to be inefficient or contributing to the efficiency of administration without factual determination, it would be discriminatory on account of race, and that would be impermissible under 15. As the determination of the data on the efficiency across the board in respect of reserve category would amount to a discrimination on account of race, which is prohibited under 15, we also have to hold that the requirement of obtaining data on effect of efficiency in administration because of the reservation meted out to the reserve category would also be violative of 15 of the enhanced impermissibility. As the three contention raised by can I allow him to read this?
Oh, yes, sure.
I'll come in again.
As a determination of the quantifiable data on the efficiency of administration across the board in respect of reserve category candidates would amount to a discrimination on account of race, which is prohibited under Article 15 of the Constitution of India. We also have to hold that the requirement of obtaining quantifiable data on effect of inefficiency in administration because of the reservation in promotion meted to the reserve category candidates would also be a violation of Article 15 of the Constitution of India and hence impermissible. As the three contentions raised by Mr. M. K. Chaudhary, learned senior counsel for the petitioner in writ appeal number 239 of 2022, are answered as indicated above, meaning thereby that as per the judgment of the Honorable Supreme Court rendered in paragraph 36 in the Jarnail Singh 1 Supra, there is no requirement of obtaining quantifiable data as regards backwardness, and as per the judgment rendered by the Honorable Supreme Court in paragraph 116 and 126 of the BK Pavitra 2 Supra. Quantifiable data on inefficiency in administration across the board in respect of the reserve category candidates cannot be obtained, and further, as the quantifiable data in respect of adequacy or inadequacy of the representation of the reserve category candidate can also be done at the level of the DPC in respect of the cadre for which the promotion process has been initiated. We are of the view that the prohibition imposed by paragraph 47 in judgment dated 23/12/2015 in Equality Forum 1 Supra would have to be understood in the manner indicated. In other words, as there would not be any requirement of obtaining quantifiable data on backwardness and inefficiency in administration and obtaining the data regarding adequacy or inadequacy of the representation can be done at the level of the DPC, the prohibition imposed by paragraph 67 in Equality Forum 1 Supra would no longer hold good, subject to the condition that the DPC, before embarking upon such and every promotion process, undertakes an exercise the adequacy or inadequacy of representation of the reserve category candidate in that particular given cadre where promotion is sought to be made. 44. Now, as regards the interpretation of clause 4 of the office memorandum dated 3/8/2016, we again quote the same provision, which is as below. Clause 4. If an occasion arises during the promotion process in which stipulated percentage in respect of reserve category is met, but in the gradation list, seniority list, there are candidates of reserve category who on merit is entitled to promotion. Her case shall be considered for promotion on merit if such candidate has not gained the seniority by way of any accelerated promotion earlier. 45. A reading of the clause 4 makes it discernible that if an occasion arises during the promotion process in which stipulated percentage in respect of categories met, but in the gradation list seniority there are candidates of reserve category candidates who on merit are also entitled to a promotion, her case are to be considered for promotion on merit only if such candidate has not given seniority by way of any accelerated promotion. It would mean that if a reserve category candidate is seeking for a promotion against any post in the promoted cadre, which is earmarked for a reserve category candidate, he would be entitled to the benefits of consequential seniority as provided in the office memorandum dated 12/3/2002. But on the other hand, if the post earmarked for the reserve category candidates are already exhausted by being occupied by the reserve category candidates, but in the gradation list, there remains some further reserve category candidates, they can compete for promotion against the unreserved post. But in such event, they would not be entitled to the benefits under the consequential seniority. And on the other hand, if on the basis of their seniority otherwise, that is, without taking note of the consequential seniority, they are within the zone of consideration, such candidates can be considered for promotion. 46. Upon the issues being raised in the present appeals having been decided in the manner indicated above, it is further provided that the decisions rendered in the judgment in WA number 46 of 2023, WA number 162 of 2023, and WA number 239 of 2022 would prevail over all such provisions of the learned single judge in the judgment dated 6/6/2022 in WPC number 5005 of 2016 and 5026 of 2016. But in respect of any other provisions which may not be contrary or inconsistent with the provisions of this judgment, the same may prevail, but with a further clarification that if any such provision of the judgment of the learned judge is in conflict or contradictory to any of the provisions of the present judgment, such provisions and the judgment of the learned single judge stand modified accordingly. 47. It is stated that in the meantime, by the office memorandum dated 18/1/2023, the provisions of consequential seniority has been withdrawn and the catch-up principle has been reintroduced. We are not observing anything on the merit of the state office memorandum, and as we have been told that the state office memorandum is under challenge in separate writ petitions, which shall be determined on its own merit, the consequences of such office memorandum shall also be subject to what may be provided in such proceeding. Writ appeal stand disposed of.
Yes.
So basically, the contention of the learned single judge on the area that on meritorious reserve candidates, they cannot be deprived of
The
their.
interpretation, the ratio of this judgment is in para 45.
Yes. Well, the ratio of this case is that if you compete for those in which for the reserve quota, you will get the benefit. But if you compete for the on merit, because Lordship, he ends up with the that if on the basis, not on the basis of consequential seniority, because when we go up, we don't want consequential seniority. We are already up. We want that we should be allowed to compete on merit without any fetters. And clause 4 of the earlier, and this OM has brought the fetter.
Prime FAC division bench seems to have held otherwise.
Bala?
45.
No,
To your
the division bench is not there because the division bench has to be within the four corners of RK Sabharwal.
Then you are agreed, you go in further appeal.
No, Bala,
But division bench,
it's an obiter.
but it's a binding precedent as far as I am concerned.
Yes, Bala, it's a binding principle. Bala, we are not on that. Paragraph 44, what he has said, that the issue was that whether we could compete when we on merit we compete. The learned single judge division bench rightly said that on merit when we compete, if we are in the zone of consideration, we horse the seniority because we don't want any consequential seniority when we go up. Because our entire case of all these 60 officers are that we were.
See, what probably is a problem.
Yes.
Seniority is guided by the service rules.
Yes, yes.
So for every promotion,
yes,
there'll be a qualifying service required to be undertaken,
yes.
right?
Yes.
Now, if for a particular post,
Yes.
particular cadre,
Yes.
you go for promotion, you say go for selection,
Yes.
and if you go strictly by the service rules,
Yes.
there may be no reserve category candidate fulfilling that requirement of
Yes. Yes. Correct.
service.
Yes.
Which is why this benefit of being promoted to the reserved post is being given. So they are picked up and given a promotion to the reserved categories.
No, my lord, the reserve category, the prescribed percentage is always compliant because
That's
the Assam government say we will give you promotion.
That's right. That's right. But now when the next promotion comes up, the question is, do you fulfill that requirement under the service rules?
Well, can you put the factor? Because the requirement under the service rule is that at each stage, the cadre promotion is the deciding factor. The Assam government now, I have not gone through page, the OM of 2023. The last time I could not show, today I'll show. What they did, they started making two classification, A, B, C, D. And they say that the A means those in the higher cadre will not get benefit, B, C, D will get. Well, it is bordering on absurdity, nothing else. But then your lordship will come to one
But then we'll have to deal with para 45.
Malon?
We'll have to deal with para 45.
Yes, Malon, para 45, because the para 45 has not deviated from RK Sabharwal. Because the RK Sabharwal's issue was the issue of Bhagwan Patar. The learned single judge has never said that meritorious persons who on merit will never be given the promotion because he adds in paragraph 44 towards the end. Yes, that Malad, lordship will see that at paragraph 45, towards the end, he adds up. But in such event, that would not be entitled. And on the other hand, well, he doesn't stop there. The learned division bench knows about R.K. Sabharwal. And if on the other hand, if on the basis of their seniority otherwise.
What is that otherwise?
Well, otherwise means under the rules I am entitled, if I am entitled. And already I'm a senior, but you took my seniority. Well, the entire case before this Guwahati High Court is that my seniority of 20-25 years, because your lordship is very right, the qualifying service is the criteria for promotion to higher cadre. Now, the Assam government.
Let us go through that memorandum.
Yes. Definitely. Lordship will come to page 107. 107. 108. Well, the memorandum of 18.
You are aggrieved by what, clause 4?
I'm aggrieved. One, I cannot be aggrieved because policy of reservation continues.
4.
I'm aggrieved by 4.
4.
And A, B is, I'm getting it, and 3 and 3. Well, 3 and 4.
3 and
4A.
There is no 3 here.
Well, there is 3. After 2, there is 3, Lordship. At page 108.
Okay.
If no eligible income, at that I'll come. This is one of the ground of challenge, D reservation.
Okay.
But first I'll deal with 4. Because 4, I will show that whatever offending clause were negated by the single judge and division bench has been brought in.
Now let us
Come to 4.
you take us through start from clause 2 onwards, so that we find out what is the flow in the in the office.
I'm not agreed by 3.
So it doesn't matter, but so that we understand what is 3 and 4.
Yes. 2. First is policy of reservation in promotion shall continue. 2. Each establishment, while taking up the process of promotion in a particular cadre of a service, shall examine the representation of the SC, STP, and STH candidate in the cadre in comparison with the prescribed percentage of reservation and calculate shortfall, if any, in the cadre with reference to the particular year. Shortfall of reservation of a particular reserve category in cadre means the difference between the total number of reserve posts for the cadre for that category in that cadre and the number of persons of that category holding the post in a cadre. While calculating the shortfall, all candidates belonging to the same category, SC, STP, and HILs, shall be taken into account irrespective of the mode of entry into the cadre, whether on account of seniority cum merit or merit cum seniority, as the case may be, or through any other process admissible in law or by way of reservation. If in a particular cadre, SC, ST are not adequately represented and shortfall is found to exist in that cadre, it would be considered as inadequate in representation insofar as that particular cadre is concerned. Such shortfall shall be filled up by the concerned category of incumbents within the zone of consideration, either on account of seniority cum merit, merit cum seniority, or by way of providing reservation as the case may be, till the prescribed percentage in respect of the category is achieved. We have no grievance. Third, if no eligible incumbents belonging to the shortfall category is available within the zone of consideration, there will be further substantiate the status of backwardness and inadequacy representation of the category in the cadre, and therefore the number of posts that are required to meet the calculated shortfall shall be kept vacant, and the vacancy will be carried forward and filled up in the next year. In case sufficient number of SC, STP, and STPH fit for promotion against reserve posts are not available, and if the posts cannot be allowed to remain vacant on account of maintaining efficiency in administration, the appointing authority may with full justification refer the vacancy to the Department of Personnel.
This is for de-reservation.
Yes, there I have a case because de-reservation after the 85th Amendment not.
The prima facie not proper for dereservation.
Supreme Court has said, how can you deal it? Well, can this personnel department has given them, who has given them authority to do whatever they like? They will slice out one part, add one part, delete another part. And the 4A is very important. But I'll be placing a judgment of the Supreme Court, one judgment on the point of clause 3. There's only one judgment.
We'll come to that.
Yes,
We'll
yes.
come to that.
Then clause 4 is very important. Then I'll make my submission. In case of
Clause 3 will become relevant
for the purpose,
only in the event it is held that there can be no vacancies available.
yes.
If you pick up the reserve category as per the RUSTA, if that principle is to be adopted.
Yes, well, that was a principle adopted in the vacancy base. Now,
Right.
after replacement theory, where's the question of always someone will come and replace?
Right.
4A. In case of promotion in group A, well, from where they got group A, we don't know. The quantum of reservation of SC, STP and HILs in promotion.
Group A is not defined.
No, my lord, because suddenly the group A comes in and group A has been held to be impermissible groups in journal seeing, because by group, what they did, the mischief, they took the entire service as a unit, meaning from my entry to service, they took a ticket and ignoring the cadre, and I lost out. Because if they can take that period, they wanted to give benefit to the general. What they do by subterfuge, they ignored the cadre and they made a column in the gradation list, unheard of. And till now, the government of Assam has not been able to show what is that column. The column says date of entry into initial APSC list. Well, there has to be some semblance, presentness, a semblance of normality.
All right. Then
in case of promotion in Group A class services, the quantum of reservation for SC, STP, STH in promotion shall be as per the stipulated percentage of reservation available for these group categories. However, SC, STP, STH servants in Group A service on their accelerated promotion by virtue of rule of reservation shall not be entitled to consequential senior. Again, they bring in the 60. The application of catch-up rule will allow eligible. Where is catch-up rule? We can give some sort of discretion to the government, but the government cannot take a dead article. Principle. The principle of catch-up rule will allow eligible officers who were senior in the merit list at the entry level in Group A service to regain their seniority in the promotional post once they are promoted to the same cadre as an officer of reserve, provided the officer of the reserve category has got his promotion ahead of any officer senior to him in the merit list. By way of accelerated promotion on account of reservation in promotion in a particular cadre, seniority of government servants in Group A services shall be revised as per the above principle. Your Lordship will see now. Further, an officer promoted from B to A service will also gain his seniority in Group A on promotion vis-a-vis his compatriot in Group B, provided that the officer was senior to the reserve in the particular B category, cadre, prior to the promotion of the reserve officer into Group A. Seniority of such Group B servant promoted to Group A shall be revised accordingly in Group A. Now, the last portion is important. They bring in the clause 4 of 16. If any occasion arises during the promotion process in Group A, in which stipulated percent in respect of reserve is met in the next promotional grade, but in the zone of consideration there are candidates of reserve who on merit are entitled to promotion, their cases will be considered for promotion on merit if such candidate has not made into consideration by way of any accelerated promotion earlier by virtue of the rule of reservation. This is in direct conflict of again R.K. Sagarwal and also the rules of the state government. The Assam government has already a set of rules in the form of OM of 14, which I'll now show how they did. This part could not have been done. I'm taking your Lordship to a very important OM of the Assam government.
So you are aggrieved essentially by 3 and 4.
Malad?
Your challenge is to the 3 and 4.
Yes, 3 and 4. Malad, here, your Lordship will take up page 60.
Oh. 60.
Yes, of the 363. 363, page 58 is the OM of 29 December 2014. Well, there I'll show how it is informative. Well, this was an OM brought after the post-based reservation. Lordship will come to the operative part, page 60. Well, these were the set of guidelines how roster will work. And these guidelines were in terms of RK Sabharwal. So Lordship will come to page 60.
Yes.
Down below, SC/ST candidates appointed on merit. Lordship got it?
Yes.
3.1. In case of direct recruitment and promotion, SC, STP, and STH who have been appointed on their merit and owing not to reservation would not be shown against reserve. They are to be designated against unreserved. 3.2. If any unreserved vacancy arises in a cadre and there are SC, STP, and STH candidates within the common zone of consideration in the feeder grade, such candidates cannot be denied promotion on the plea that the post is not reserved. Such candidate shall be considered for promotion along with other candidates, treating him as if he belongs to the general. In case he is selected, he shall be appointed to the post and shall be adjusted against the unreserved, categorical. I cannot be touched. 3.3. Similarly, SC, ST, STH candidate appointed on their own merit by direct recruitment or promotion, our case is promotion, and adjustment against unreserved posts shall continue to retain their status as ST, STH and will be eligible to get the benefit of reservation in the next or future promotion in the this, after this OM of 14 is there, what was the necessity of bringing an OM of 16 and 18 to bring in this clause 4, which says that you will be barred, there will be a fetter. I mean, on one hand, you bring an OM in terms of the
This OM was superseded.
No, it was never superseded because it cannot be superseded because if they supersede, Assam government is now in a precarious position. If they supersede this, then the entire post-based reservation in Assam will be will abrogate. Because I'll show the Chief Secretary of the state of Assam, but I have brought on record. Your Lordship will take up my 365.
1 minute.
Well, it is incongruous, unheard of. Already provision exists. I cannot be put fetters. Well, what has happened in their overzealousness of protecting a particular class, now they forgot that they are violating the constitution also.
Yes.
Well, this is an affidavit given by the Chief Secretary of the government, of the Chief Secretary, before the division bench in the year 2011 when a reservation case was going on. I was also a party, and your Lordship will see that the Deputy Secretary, Joint Secretary files this affidavit on behalf of the Chief Secretary. In para 2, your Lordship will find that a deponent begs to state that the scheduled caste and scheduled tribe vacancies of service and posts of 78 Act was amended in 12 to implement the order passed by the Honorable Supreme Court of India and R.K. Sabharwal. The scheduled caste and scheduled tribe river was published in the Gazette of 25 August 12 and it has come on 27 of 5/13 by the Gazette notification on the appointed date. The rest is not important because data was called for. So the Chief Secretary of Assam himself through an affidavit swears an affidavit to the extent we will comply letter and spirit of R.K. Sabharwal. Means cadre wise. There cannot be denial of merit And today in 2016 and 18, you bring in an OM completely dislodging them. In fact, this was the reason why I made a submission that the present Chief Secretary, in his letter of 6 December 2023, curiously does not mention about cadre. He talks about grade. And in service law, grade talks about pay scale. Our promotion never goes by pay scale, though promotion we get a higher scale. But the present Chief Secretary either is ignorant or he is not informed by the personnel department, because the personnel department is the epicenter of all the illegalities which is happening now in the entire country. In fact, Lordship, this is a case where your Lordship, after the judgment, needs to pass strictures, because why? There is no cadre in the Assam Civil Service. There are 1,000 officers in the Assam Civil Service who doesn't have a cadre for the past 25 years. And the fact that all officers have retired, losing their seniority, it is only that our case has taken up this issue. Well, now it has opened a Pandora's box. So what I'll say, after the division, after the Chief Secretary of the Assam government, the head of the bureaucracy, gives a sworn affidavit, it could not have been, it was the bounden duty of the personnel department and the councils for the government of Assam to place this before the court. The Assam government never placed it in their affidavit. As a result, my lord, for no fault of us, this sort of illegal, unconstitutional OM of 18 is brought in. My lord, we lost our seniority, not only in terms of the rules, but also in terms of the constitution. But I call upon your lordship, this is a case where judicial intervention is required. This OM needs to be quashed, and the entire seniority of all the officers of the reserve needs to be redrawn, and by going by the cadre rules. So in fact, the Chief Secretary also did not file his affidavit. Lordship will see the earlier last order specifically directed the Chief Secretary Assam present to file a detailed affidavit on this issue. He didn't file it. He left it to a Deputy Secretary to file it, because he knows that he cannot do it, because if he does it, because if he uses the word cadre, he will have to comply with IV Guhai. And if he complies with IV Guhai, he will fall within the contempt duty. So in order to escape, he uses it. Then your lordship will come to the next paragraph. Yes, B.
Paragraph where?
108B. I'm taking your lordship to the OM again. Clause 4B. Can I read? In case of promotion in B, C, D services,
Yes.
the quantum of reservation for SC, STP, STH is promotion shall be as per the stipulated percent of reservation of those categories. The SC, STP or STH government servants on their promotion by virtue of the rule of reservation shall be entitled to consequential seniority. This we will get it. Down below we will get it. In other words, candidates belonging to general OBC, MOBC category promoted later will be placed. Malad, in their zeal, they lost one thing. Malad, Assam government forgot that OBC, they never get any benefit of promotion. Malad, they forgot also. Will be placed junior to the SC, ST candidates promoted earlier. Seniority of government servants in B, C, D shall be revised accordingly. And last paragraph, lordship, then 5 I'll read. As regards the question of maintaining efficiency as required under 335, it should be assessed applying the objective standard, annual confidential report of the incumbent along with length of service, participation in training, job requirement, acquisition of degree, diploma, if mandatory, may be considered. My lord, length of service, my length of service is gone now. Since they don't take the cadre, that is gone. Last 6. It shall be the responsibility of the concerned appointing authority, that is the government, to provide adequate information concerning the above to the selection committee, which shall evaluate all relevant parameters while making it recommendation. And the last part is very important. This office memorandum is issued in supersession of the OM of 12/3/2002 and the OM of 16, I do understand you are replacing. Supersession means replacing. You are replacing the OM of 2016. But who has given you the authority to withdraw 12/3/2002, which has held to be enforced by the single and the division bench? Well, this is a pure and simple contempt of Bhagavan Patar. Because they know that they cannot remove it. Because if they remove it, they will have to abrogate 1978 Act. So in my humble submission, the action of the government is without any rational, intelligible differentia. They have categorized service into two categories: A service, B service, C service, D service. Who has given them the authority to divide the service? And who has also given them the authority that we as masters will now give benefit to the lower categories, and as they go up, we are going to remove it, and upper we will not give. In fact, this OM is in direct contravention of R.K. Charnel Singh. In fact, your lordship will find that in one of the affidavit, the secretary of the department.
Why do you say it cannot be withdrawn or superseded? 2002.
Can the OM of 2002 be withdrawn without the section 5 being withdrawn? Nowhere. Then you basically make an announcement.
Where is that OM of 2002?
Yes. Because the OM of 2002 has come after the catch-up principle has been withdrawn. Page 46, your lordship will come. Your lordship will come to page 46.
Yes.
This is the office memorandum of 11/12 March 2002. Personal department OM, consequent upon the amendment of Article 16(4) of the Constitution by the 85th Amendment, it has been decided that the following principle of fixation of seniority of reserve versus general in the promotion post shall be followed. Scheduled caste, scheduled tribe shall be promoted by virtue of the rule of reservation roster, be entitled to consequential seniority also, and the above decision will be effective from 17 June 95 because it made retrospective. On the basis of the reservation, seniority consequential benefits like promotion, pay, pension shall be allowed to the concerned scheduled caste, scheduled tribe, government servants without areas by applying principle of no work or no pay. For this purpose, senior scheduled caste, scheduled tribe servants shall be granted promotion with effect from the date of promotion of their immediate junior, other OBC. Such promotion may be given with the approval of the appointing authority of the post to which the government servant is to be promoted at each level after following normal procedure of DPC and with the concurrent approval of the APSC. Except seniority, other consequential benefits like promotion pay, including retirement benefits in respect of those who are already retired, allowed to general OBC government servant by virtue of implementation of the office memorandum dated 12/6/96. That is catch up, and in pursuance to the direction of the tribunal should be protected as personal. The instruction contained in the department's OM of 12/6/96 stands withdrawn with effect from 12/6/96 itself, and seniority of government servant determined in the light of the office memorandum shall be revised as if that memorandum was never issued. The personnel department has already issued an OM, and the OM of 2096 bringing catch-up principle at page 44 is withdrawn. Now to say, it is very shocking on the part of the government that the additional Advocate General makes a submission that for the petitioner, where they got this, that the catch-up principle is not there. This is your own document or your own department, personnel department, which has withdrawn the catch-up principle. So after 96, how can in 2023 the catch-up principle be brought in? Well, what more brazenness is required? In fact, the 2006-96 catch-up principle was, in fact, they make a categorical statement that it will be considered as if it never existed. But now, by bringing it through backdoor, you have taken our seniority. In fact, our seniority, we lose our cadre seniority retrospectively for no fault of ours. And we go down the ladder, and everyone and what has happened to our 25 years of earning cadre promotions? If I may now show the cadre rules, I'll just take your lordship because this case is connected with 665. The Langthasa's case. Well, what has happened? The vacancies which occurred when I challenged this OM, vacancies arose and I was supposed to get it. But the government said that OM of 18 has come in, you will not get it. We will now take the initial entry into service as the length of service and we will
OM of 18?
18/1/2023, we lose all our seniority and in 665, that is item 8, Langthasa has filed, Radhesam Langthasa has filed 2 cases. One, he has challenged the constitutional validity of the OM and the 665 is an elaboration as how I came down. Item 9. Well, item 9 is the same, only I will just point out how I lost my seniority in the cadre.
Item 10.
In item 10. Because other cases will be very similar. All officers after 8, 9, 10, 11, 12, 13 till 18 are same principle. You bring in the 2018, you take the entire service of the general, no cadre, we come down. Given it? 665.
Yes.
My lordship will come to the gradation list.
Page number?
Your lordship will come to page 119, lordship. 120, sorry. This is the provisional gradation list prior to the OM of 2023. Lordship will come to serial 11. 11 is Radhesam. Lordship has got?
Yes.
Your lordship will see the first column talks about date of birth. The second column takes of date of appointment in the department. And the third column is the cadre, the date of joining as SC.
Yes.
I come to the cadre in the year 2018. So naturally, it is expected that under the rules of the engineering service, I am senior in the cadre. I come to the cadre on 2/6/2018. Lordship has seen?
Yes.
Your lordship will now come to serial 2 of the gradation list, Probin Bhuyan. The respondents now. They come to the cadre after me, lordship will see date of joining
Why
as
not?
superintendent engineer,
Why not serial 1?
21/12/2020.
Why not serial 1?
Serial 1 belongs to the reserve. He has retired also.
Okay.
He has got his promotion. Provin Bhuya, he is the general. 21/12/2020, I come to the cadre. So I come to the cadre later than Langthasa. Mrs. Mandira Sharma, she comes to the cadre.
They are unreserved.
They are unreserved. On 18/12/2020, after me, Bhaskar Sharma, 18/12/2000. Then Rajiv Goswami, 18/12/20. Nageshwar Kormokar, 18/12/20. Nayak Narayan Soikia, 22/12/20. Samiran Deka, 28/12/20. Subrata Nath, 24/12/20. Abdul Munin Mozumdar, 24/2/2020. Malad, I should have been after serial.
What is the final gradation list?
Yes, the final gradation list comes in the day when the OM is issued at page 125. The provisional gradation list, page 125.
Yes.
The provisional list of superintendent engineer under water resource department is hereby made final. And that is the date when the OM comes in. Lordship will find 18/1/2023. Now your lordship will see the final gradation list in the rank of civil engineer. All go over me. I come down at serial 17. I lose my seniority. My position should have been at 2 after Deep Pegu. Rules here. So your lordship will
This
find that,
gradation list is under challenge.
my lord, yes, we have challenged this subsequently, and your lordship will find, curiously, they bring a new column which is not advises in the rule. Lordship will see the last column, recommended
Last
by
column.
APSC,
Okay.
page 126.
Hmm.
1, 2, 3, 4, the fifth column, the last column,
Yeah.
126.
Yes.
My lord, they bring in
Recommended.
APSC. Yes, my lord, APSC naturally, the reserve, the general where we came later on, we got our accelerated promotion. So they forcefully brought in that and they showed that this is your length of service, you go. We forget your cadre. In fact, now I'm placing the cadre rules because once your lordship, this is a clear case, the other case are on the similar footing. All coming down, they opening up a cadre, one more column of date of entry. Hello, where is my qualifying service gone? Everything is erased. And the rules of the PWD, the engineering and the civil service are in perimetry. It is always cadre wise. My lordship, paragraph 13, rule 13, your lordship will come. General procedure for promotion.
Yes.
Before the end of each year, the government shall make an assessment of the likely number of vacancies to be filled by promotion in the next year in each cadre. And in fact, the gradation list has to be made cadre wise. Your lordship will come to page, lordship will come to rule 22. Rule 22, the seniority, all perimetry. The seniority of a member in a cadre appointed by direct recruitment or promotion shall be determined according to the order of merit in the respective select list. Each cadre will have their selection process. Well, to say that by my learned friend that it is all subterfuge. Well, we have not gone up by subterfuge. Through a dedicated process, we went up the ladder. And your lordship will find paragraph 24, rule 24, the gradation list.
Yes.
There shall be prepared and published every year a gradation list, containing the names of all members of the service cadre wise, in order of seniority and such particulars as date of birth, date of appointment. It nowhere mentions that APSC list will be brought in. So forcefully you bring in because through subterfuge now you want promotion. And the fact that after journal, the law is clear, you cannot make it any group wise. It has to be cadre wise because if it is group wise, the member of the SC/ST will never get any promotion higher up in the higher echelons. Because they will always be down below and they will be denied promotion in each selection committee on the ground that you don't come within the zone of consideration. In fact, there are cases where Mr. Subrata Das and Mr. Bhagawan Patar, he himself have to come. My lord, it is unfortunate that a person who won the case now again has to go on for litigation at a division bench. So they have been brought down from their higher post. And in fact, I will just paragraph 45 to 7 I'll read. Well, that clinches my case of my compilation. So another thing I forgot, Lordship. Lordship, I'll show that the Assam government, yes, the Assam government has found out an ingenious way. In all their case, they take a specific stand that we will give you seniority, we will not give you seniority, we will not give you cadre promotion. But the Assam government in the secretarial service is following the cadre rules. Means at the sweet will, the Assam government, in the Assam secretarial general administration, they are following cadre rule. Absolutely, there is no problem. It is rule compliant. I have shown through RTI, I could get this. Your Lordship will find that there are different columns in compliance with the rule. Your Lordship, we'll find date of birth, date of entry in the government service, date of promotion in the post of under secretary, that is a cadre, and date of confirmation in the cadre. Well, it is so compliant, rule compliant. In the soil conservation also, I won't trouble your lordship, they are doing cadre wise. But in the Assam Civil Service, they make it into grades. And your lordship, nowhere in, possibly in India, the civil service, which is supposed to be the backbone of administration, does not know what is their service condition, because they are grouped into a one grade and 1,000 officers are in, they don't know what cadre they are in, and promotions are being affected. Virtually vacancy-based promotion are being followed in the name of post-based reservation. So your lordship will take judicial notice of these facts, and lordship, I'll be just referring to some judgments to clarify the points. In fact, 2 points I have already clarified. Mr. Chaudhary's remark that we go on selection to the higher post by subterfuge is strongly refuted. We go by selection.
Yes.
Mukunda Sharma's case, Mukesh Kumar's case is not applicable in my case. Mukesh Kumar's case is a mandamus can be issued when promotions is not. In the state of Uttar Pradesh, Uttarakhand, they have taken a decision not to give promotion, a reservation, but now they have given. So they went to the Supreme Court. Supreme Court, I comply with the, I fully strongly agree with the Supreme Court judgment. Why will the court issue mandamus? But in Assam, we have an OM which is giving us enforceable right. It is already enabled. And another thing, an argument was advanced by my learned friend, Mr. Mojumdar, that Mr. Das has got from where he got the catch up. I want to ask him from where. He will have to show that the OM of 2002, which has withdrawn the 96 OM of catch-up principle, has been again brought in. Because insofar as the OM which they brought in catch-up principle, they basically made into two classes without any intelligible difference here. And a lordship knows under the constitution, there cannot be class legislation. You are categorizing services into groups. A, B, A you will get, B, C, D, you will get, top, as you go, you don't get. So virtually it's a blatant discrimination, not only violative of Article 14 arbitrary, it is violative of modes of public employment, Article 16, it is violative of Article 15, it is racist. You are categorizing and singling out the members of the reserve. Lordship will come to page 305 of my compilation.
Why 305? What are the other judgments?
Why 300? Because what has happened after Journal Singh 1, the Supreme Court found out that in many states, cadre promotions were not being given. So in view of that,
you have referred to so many judgments. What are these judgments for? What purpose?
Most relevant regarding my seniority, which the OM 2018 OM, the categorization which they have made into groups, taking the entire service as an unit is impermissible when the cadre rules provide for cadre wise. And the division bench has also said, paragraph 47. In fact, the Journal C2.
So if you are referring to a judgment, then you will have to take us through the judgment.
Yes, my lord.
The entire judgment, or at least the relevant portion.
To be precise, after going through the judgment, the ratio if your lordship wants that I start off.
Of course, you are familiar with the ratio, but for the benefit of
I can indicate, lordship will go through, but I can indicate which paragraphs.
We can go through anyway. We don't require your assistance for that. But if you are referring to a judgment, then we request you to refer to the relevant paragraphs with the reference to the facts of the case.
Yes, these cases have come up because the issue was whether cadre promotion, why was the state governments not giving cadre promotion
This
in
is
India?
Journal Singh 1.
This is Journal Singh 2.
It's not reported.
I don't know. I think it is
Give us a reported printout.
We'll give the reported. Wait. Reported to source 1.
You are referring to earlier Journal Singh, in the division bench judgment, reference was made to Journal Singh one.
I'm referring to very important cases, 3 cases.
Huh.
Mala, Journal Singh 2 was referred.
No, I think it is Journal Singh one in division bench.
No, Mala 2. In Bhagwan Patar also, Journal Singh 2 was also.
Okay. We'll continue the hearing.
Yes. Yeah. Then,
Number 31 of the.
You can come back with the judgments.
Yes.
On some other date.
Yes.
Hard. Oh, sorry. Let the stenographer come.
But as regards the other cases, can I not, well, one thing I'd like to just point out.
You can give us a chart.
Yes, those are
with all the particulars pertaining to the each writ petitioner,
individual
which
cases.
department,
That
date
will
of
be
posting,
better.
date of promotion, etc. You make a chart and give the writ petition number.
Yes.
So that it becomes
Easier
convenient for us to.
Because whatever principle is laid down will follow.
Ah.
Only one thing I'll make to have to make a submission for this condition. Well, certain cases, your lordship can segregate. Well, your lordship will find that cases start from 3, 3, 4, 5, 6, 7 till 7. Lordship, what has happened? These were cases where the 2018 OM was never applied. The 2016 OM was applied, which was set aside. The clause 4 was set aside in Bhagwan Patar and Ivy Goai. Those cases 1 to 7, since today your lordship is not having time, your lordship will segregate it because I will call for implementation of the order because now adjudication is not required. On
No,
those
not
cases,
segregate. You argue separately.
Yes.
If you want. You argue separately. What is the point in segregating suddenly now? We'll have to take a call whether it needs to be segregated from.
Next day I will make my submission. And in fact, there is a judgment of our Guwahati High Court also. The OM will always cannot be retrospective, prospective. So these cases are 16 OM is applicable. So I want an implementation.
Heard. Mr. D. Das, Senate Counsel, assisted by Mr. Petala, for the writ petitioners in WPC 363 of 2023 and
365.
365.
The 665.
Sorry, 665. 665, 2023. Hearing, matters were heard in extenso. Hearing remained inconclusive. For further hearing, list on for the respondents, Mr. C.K.S. Borua, Mr. D. Mazumdar, additional AG, assisted by Mr. C.K.S. Borua. Then Mr. Gautam for respondents 2 and other councils are there for PWD and tribal affairs. We can have it on 1st February?
Yes, yes.
1st February.
Okay.
Further hearing on 1st February.
Okay. Okay.